There they are.
There.
Good afternoon. Welcome to the House Economic Matters Committee. It's Thursday, February 5th. We have a number of bills today. We are going to ask, just so folks know, sponsors generally get unlimited time, but we have many bills, and so we ask you to use an economy of words to the extent that you can. Sponsors and everyone else is limited to 2 minutes of testimony. After the first panel, we'll take questions, and then subsequent panels can come up, or we'll go to the virtual folks. So our first bill is Delegate Baylor, House Bill 431, and if you want to bring up your panel with you. You can start when you're ready.
Great. Thank you, Madam Chair, and I'm happy to be in the best committee in the General Assembly. Thank you, thank you. And we do miss Ben and E&T, so. But for the record, I'm Delegate Dylan Baylor, representing District 30A right here in Annapolis, testifying in support of House Bill 431. This bill was brought to me by the Maryland Society of Surveyors, who I'm joined with here today, and it does three important things related to platting, which is a new topic to me. And broadly, it enables the digital submission first. It updates survey standards for GPS technology, and it clarifies important terminology and updates the fees after quite a long time. So we are aware of MBIA's opposition, and we're in constant communication with them to try and find a path forward. And with that, I would respectfully request a favorable report of House Bill 431. Thank you.
Madam Chair, Madam Vice Chair, and committee members, good afternoon. My name is Bill Bauer. I'm a licensed professional land surveyor and civil engineer. I represent the Maryland Society of Surveyors in our efforts to modernize regulations affecting our profession. I've worked on this bill for over a year. I worked directly with the Maryland Archives to come up with the language. It doesn't permit the submittal, or it doesn't prohibit the submittal of paper plats. It just allows for the digital transfer from a local government to the Maryland Archives. And it also removes references to antiquated survey methodology. The Maryland Society of Surveyors respectfully requests a favorable report for House Bill 431. Thank you.
All right. Thank you. Bill, I have you as virtual, but it looks like
I'm virtually in person.
You're here in the flesh,
That's
so
true.
go ahead.
Thank you, Madam Chair, members of the committee. Bill Kress here on behalf of the Maryland Society of Surveyors in support of House Bill 431. I just wanted to address the cost issue. So as we were working on this legislation and updating the language within the code to harmonize it with modern techniques, the fee of $25 per page was something that the archive suggested. We're somewhat agnostic to what the fee might be, but the fee was set in 1974 at $5. With inflation, that comes out to $32 today. So that may give you some guideline of how the committee might want to approach this. Again, we're not wedded to a particular fee. We think it should be reasonable. We think the $5 fee probably is not enough to cover the actual expense. Thank you, Madam Chair.
Thank you. Are there questions for this panel? Delegate Adams.
Okay, so what are we trying to solve here? And the reason why I ask that is there was something that was happening with the archives that was creating some frustrations for attorneys that were having to request information. And is there a nexus between this thing that I can't remember, but I do know
we are, not to cut you off, Delegate, we are aware of that issue and we're working on that issue as well. This has nothing to do with that. This is just a cleanup of the statute, and there happened to be a fee associated with the filing. And so we try to update the fee based upon conversations with the archives. The issue you're referring to is a budget issue. There was an attempt by the archives to increase fees. There was a big outcry from the community, and that is on hold. I understand that there's legislation dealing with that specific issue, but this has nothing to do with that.
All right, well, that's my only question. Try to connect it.
Okay, thanks. Delegate Chi. Oh, did you have, sorry, I had written. Sorry. No, you're. Other questions? No, I can't, but now I can.
No, I mean, where should I put it?
It's closer to you because the window's right there.
I see,
so
okay.
Delegate Piffy, it was not personal,
All right,
please.
there you go. Best for last, I guess. So it goes from $5 to $25 per page. So on average, how many pages are we talking here?
Yeah, it's a great question. So we took a look at the data from Anne Arundel County. It averages 2 to 3 pages on a typical filing. So you're looking at $50 to $75.
Okay. Would you consider the bill without the fee increase?
Yes.
Okay, all right, thank you.
Any other questions for the panel or microphones they're hiding in light? Okay. Thank you for your testimony.
Thank you.
We'll go to unfavorable. Is Bob Enton here? I don't think I see him.
Oh, no.
Bob Enton, going once, going twice. He's in the hallway. He's about to lose his opportunity. He's making his debut in the committee, right? Or was he here yesterday? All right. Well, I don't see Bob, but we can read the unfavorable testimony. So that concludes the bill hearing for House Bill 431. Next, we're going to go to House Bill 62. Delegate Simmons, can you come up and bring your panel up with you? As soon as you're seated, you can begin.
Thank you, Madam Chair, and my mentor, thank you for being here. Today, this is Delegate Simmons presenting House Bill number 62. Excuse me, asking for a favorable. This bill is with Anne Arundel County, summons and actions to repossess, failure to pay rent. As you know, there's a thing that's considered as called tack-ups. It's a technique in which our law enforcement agencies, Anne Arundel County Sheriff's Department use when individuals are late or behind on their rent, where their landlord sent out notices to the court, and our sheriff's department have to go out and tack up these multicolored pages on individual doors, letting everybody know that they're late on their rent and that they have to appear in court. As a result of that, the sheriff's department have determined that not only is antiquated in the sense of what they're doing when it comes to that, but this is an enormous burden on the sheriff's department that now have to be in every courtroom, and due to staffing are no longer able to carry out these duties in a way that's safe for the officers. So with that being said, I ask for a favorable. I'm going to turn it over to the panel at this time. Thank you.
Good morning. I'm going to get straight to it. Thank you, Madam Chair, for hearing this, and committee members as well. I'm wearing 2 hats today. My first hat is as the sheriff of Anne Arundel County. So the sheriff's office in Anne Arundel County has been overlooked for far too long. In the last 20 to 25 years, we've increased by about 6, 7 deputies, while the county police has increased probably by about 140. We are grossly understaffed. To accommodate this ask here of putting these tack-ups up, we require additional time. Right now, we get about 2,000 tack-ups a month, and I have 11 deputies who are dedicated to this and also serving court summonses. We try to put 2,000 tack-ups a month. It's virtually impossible for us to do. Now, let me put my hat on as an elected official like you. One of the things that I promised the citizens is that I would look out for their rights. And right now, their rights to due process is being denied them. We get 5 days to put these tack-ups up. We get them, the clock starts. We are not a 24/7 operation. We don't work on weekends. So we lose some days there. We lose days to the snow. It's impossible for us to get them up. Right now, today, you guys started your workday fairly early, I assume, just like most people. We're putting these notices on doors at 9 a.m. People already left their home. They're already on their way to work. It's not fair to the citizens, and it's definitely not fair to us to provide equal service. Now, this not only affects the citizens, it also affects business owners, because the majority of business owners lease or rent their property. I met with one of the people who oppose this. They said they have 40,000 units. Well, I like to peel the onion back. To me, it's not units. That's 40,000 family members who are not getting proper notification. Thank you.
Good afternoon. My name is Jay McCleve, and I'm the current president of Fraternal Order Police Lodge 106, which represents the deputies of Anne Arundel County Sheriff's Office. which proudly serves the men and women of the Anne Arundel County Sheriff's Office. We stand before you today in full support of House Bill number 62. The legislation represents a significant step forward in enhancing the efficiency and effectiveness of our court process related to housing disputes by allowing the district court to issue summons to a sheriff's designee in addition to constables and sheriffs. We're providing our judicial system with the necessary flexibility to address the challenges we face in managing case backlogs and expediting legal proceedings. Moreover, the requirement for the designee to notify the tenant by first-class mail with the court appearance scheduled for the 30th day after the complaint is filed extends an essential time frame. The extension is crucial in ensuring that tenants are adequately informed and prepared for their day in court. Additionally, mandating that the designee post a trial notice at the property at least 7 days before the trial ensures that all parties are aware of the upcoming legal proceedings, fostering transparency and accountability. It is also essential to note that the provision that limits the capacity of the designee to serve process if there are more than 100 cases per day. This guideline will help maintain a high standard of service and ensure that our deputies can effectively manage their responsibilities without becoming overwhelmed. In conclusion, we believe that House Bill 62 will facilitate a fairer and more efficient judicial process, ultimately benefiting both law enforcement and our community members. We urge you to support this bill, and thank you for your attention to this matter.
Thank you very much, and hello, Delegate Simmons. With that, we have questions from Delegate Adams.
Thank you, Chair. So,
I'm sorry. Thank you.
no, that's okay. Hi, how are you doing?
I'm good.
So we had this subject come up during a briefing, I thought, last week, and I just want to probe on a couple straightforward questions. But before I ask, I just want to make sure you and I are sort of on the same page. I'm from Wicomico County.
Yes.
And so last week when I was asking questions about this, I was getting mixed up. Wicomico County is unique in the sense that private process servers can actually do this, that the Wicomico County Sheriff's Office has no involvement whatsoever. So I don't want to get into that subject. That's not the point of the subject. But my question is, would the bill sponsor or advocates be looking for policy changes from any different perspective, not just about extending the time frame? And so if I'm being very direct on my question, would you support any policy that basically makes it such that the sheriff's office has no involvement in that step of the notice requirement?
Yes, I am open to that. One of the things that we are looking at is, just like Wicomico County, of possibly using civilian personnel to do this, but they would work for the sheriff's office.
Well, so in Wicomico inside, I've got to be careful here. This is a local bill. And so I'm asking this only because I'm wanting to be constructive and not necessarily antagonistic on the subject, because I don't know the politics behind whether the sheriff's office wants to continue doing this. I mean, this would be the right place from a standpoint of law enforcement and making sure notice is served. All I'm simply saying is that in one county, it just happens to be the one I live in, private process servers who have to follow Maryland rules. So it's not just a private citizen then. I can't, for example, do that myself. I have to hire a third party that's surely able to do it under some version of a certification or some type of legal standing to actually be able to do this, do it free of the sheriff's involvement. And it sounds like to me you would be generally on board with that subject.
Sure, if I can just add, so
Yes.
that was part of the conversation. The Judiciary Board were in on this conversation as well. They're not in agreement with, at this point, of having someone outside the sheriff's office. So the sheriff is also looking at constables and SPOs. So an expansion of that department, that is also in consideration with working sure that they work the court, right? Their primary responsibility is the duties of the court. And so they have to work closely with our judges and that system. So they are part of this conversation as we move this forward.
So I'm just going to close by saying that I appreciate what you're saying and accept everything that you're saying, that each county might have a different position on it. It was just to bring light to the subject.
Oh, yeah, absolutely.
All right.
Thank you.
Delegate Pippy.
Thank you, Madam Chair. Question, and I will take notice that it is a local bill, right?
Yes.
So I practice law, and one of the things I do is some landlord-tenant law, and I practice in all 24 jurisdictions, including this one. So my question is, obviously, if you're representing a landlord, pushing this out past 30 days creates some potential issues there, right? If you got a tenant that's not paying, this just kind of pushes that further out. But the broader question is this: have you asked for more funding? I don't know if he just said that, but have you asked so who the budget for the sheriff's office? And you're not full service sheriff's office, correct? Do you do enforcement as well, or you just do? Okay.
No.
All right. So does the budget go through the county, or are you independent?
The budget goes through the county, so let me set the framework for everybody in here. Anne Arundel County has about a $500 million public safety budget. That's for the sheriff's office, Department of Corrections, fire, and police. Out of that $500 million, the sheriff's office gets 3%. So our budget is very limited.
I understand. So I just want to know if this is a Stuart Pittman issue, or if this is a landlord-tenant issue. And the reason I say that is, and I come from Frederick, where we have, it's law enforcement in addition to the other functions, like Baltimore County and Montgomery County and places like that. But, I mean, if the county is not adequately funding, this department, I mean, because it sounds like if you had more funding, you could probably hire more deputies to carry out these functions that are carried out by your department. And I don't want to delve into it, probably as far as I'm going to go, but the question is, have you asked for this funding to solve this issue before coming to the General Assembly to change landlord-tenant law?
Okay. So when I first took over as sheriff, we had over a 20% vacancy rate.
Okay.
And I said, I'm not going to go to the county council and ask for additional people until we fill the vacancy rate.
All right.
Now we're floating around, right around 0%. We got people in the academy, we fill that void. You asked the question, is this a Stuart Pittman thing? No, it's not a Stuart Pittman thing. It's a systemic thing that has been going on in Anne Arundel County way before the Pittman administration, probably 2-3 administrations ago. This is a systemic thing that I'm working with the county on. Stuart Pittman has given me some things that we've never gotten before that has been very helpful. Now, this time in the budget, I will be asking for additional personnel.
Good. Okay. Well, I appreciate that, and we appreciate your service to the county. So,
Delegate Aarons?
Just a quick, Madam Chair, sorry. I apologize. I guess I'm coming at it a little bit different angle. I understand the problem, and I understand what you're trying to do, but the unintended consequence on this, was that a consideration on this? Because as you extend time periods, that affects the owner of the home, that affects the rent, the cost of rent. I don't know how you address that, and what have you thought about when you looked at this bill to do this, and what that's going to do to re-renting that house if you can re-rent it?
Okay, so I did take that into consideration, but it's sort of like this to me. When I owned a rental property before, and I understand that people may be late on their rent, you may have to evict someone, and there may come a time when you have to do that, but there is a certain amount of write-off that you will have to accept. But what the citizens of this county cannot accept is the fact that right now, there are deputies at their house putting these summonses on their door for court today, for court tomorrow. There is no way. That's not fair. It's not fair to the citizens. It is not fair to us because I have to spend an inordinate amount of taxpayers' dollars in overtime just to make this happen. So when you look at taxpayers' dollars compared to businesses who may lose a few dollars that they write off anyway, I think the taxpayers and the citizens win all the time.
Okay, but even with the write-offs, people still have to make money. That's my point. You're already dealing with a sad situation.
Yes.
I mean, it's very tragic. You don't want to be involved in this. But when you look at that when I have to, let's say it was you renting it out, you have to put that what you just said, those costs, that you have to take that into consideration. When you expend that time, that consideration gets greater the next time. Am I right?
I understand.
Okay. Well, thank you. Appreciate it.
Delegates, well, so when you look at a lot of renters, most renters, they have to pay a deposit fee down as well, and that money sometimes is not recouped based on what you're talking about, that extension of them being in the house past their ability to be put out or evicted. Some of those fees are recouped that way. So it's really about meeting the needs of these, of the department when they're going out on the same day serving people with these appear in court orders, where most people don't even appear in court on that same day. And now there's a judgment already in place because they didn't have the opportunity to even know that they were supposed to be in court because of staffing of the sheriff's department and their ability to get there in a timely manner based on the court issuing that
Understood.
notice.
Understood. Thank you.
Thank you, sir.
Delegate Amprey?
Thank you, Madam Chair, and thank you, Delegate, for bringing this bill, and thank you, Sheriff, for your service. My question is really quick. I'm looking through the testimony here. I know this is a local bill. It has the Anne Arundel County delegation. Do they have a letter of support of this bill, or is this just, I'm trying to understand that concept.
Sure. This will be presented to the Anne Arundel County delegation next week. Unfortunately, this came up very quick on our calendar, so we have not had a chance to present it to the delegation, but it will be as of next week's meeting.
And I know you can't predict the future, but do you expect for there to be unanimous?
I do.
Okay. Well, as soon as that letter comes, please make sure you share it with the committee. I appreciate it.
That's the intent.
All right, thank you.
Delegate Bandari?
Thank you, Madam Chair. Thank you for the bill. And on the bill, page 5, lines 10 through 12, it says sheriff designate has the same authority and responsibility as a sheriff. What training, oversight, or accountability measure ensure that a sheriff designate provides the same level of service, reliability, and due process as a sheriff?
Well, that's why when we said we're going to use civilians, that's why we wanted them under control of the sheriff's office, because we can ensure that they have the proper training, how to actually affix the summons to the door, how to actually document that they affix the summons, how to deal with different personnel, and they will also have the support of sworn personnel. So if they should come into a situation where they do not understand something, a sworn personnel will be able to come to the scene with them because they'll be issued radios just like anybody else. And I say this, we have a very progressive Office of Professional Compliance, Internal Affairs. So they would fall under the supervision and of our internal affairs as well to make sure they do what they're supposed to do.
Thank you.
Delegate Roberts?
Thank you, Madam Chair. And I apologize, I have not read the entire bill. I just want to know if what you're asking for in this bill, does it extend the time period of when the person gets the notice? And by how long?
Yes, it will. So what we're looking at is this bill will extend it 30 days. But what will happen is from the moment the bill is assigned to the sheriff's office, signed by a judge, the sheriff's office will get 23 days to affix the summons to the property. And also, you should be aware that we have to mail these out too. It's required by law that we mail them out. Mail is slower than my deputies, so they definitely get the mail after the fact. So we will get 23 days to affix the door, make notification to the tenant, and then the tenant will have a total of 7 days to prepare themselves for the court date.
Okay, so so you don't have the constables and the civilian people in place yet, is that right?
That is in my current budget that I will be presenting in March, I think, to the county council.
But you anticipate it, and if you do, and you know, we're gonna pray for this, we're gonna claim this.
Okay, all right, I'm gonna pray for this.
If you get the additional personnel, why do you need to extend the time frame?
Because it still won't be enough. So in order for us to say, cover this 2,000 piece of paper that we have to serve, I would need probably an additional 20 people to do that alone, you know? And then we're not talking about the mailings that go out as well. So in all fairness to the county council, to ask for an additional 20 civilian people at one time, I think that would be a little much. So we're taking steps, but even as this county grows, if you give me people right now, the county continues to grow, then we're back in the same boat again.
Gotcha. Understood, thank you. Thank you, Madam Chair.
Delegate Rogers?
Thank you, Madam Chair. First, point of personal privilege, I want to thank probably the shortest sheriff in the state for the great work that he's doing in Anne Arundel County. I would ask you to stand up to prove that you're the shortest, but that's okay.
On my way out.
Yeah. But I would like to ask the sponsor, I noticed there's some opposition testimony. Have you done anything to work with those in opposition to the bill?
Absolutely. So we have had the opportunity to meet. I've met with the courts as well as all additional opposition to the bill. We've had some one-on-ones with the sheriff about the legislation, obviously, and as we continue to try to work this out, I've spoken with our delegation chair about some opposition to it. So the key behind this is to make sure that not only we're meeting the needs of the sheriff's department, and the courts, which are our primary concern here, but to make sure that we get to where we need to be with this legislation in a manner that we're all in agreement with. So we kind of have some time here. We continue to work with the courts. We're going to continue to present. Hopefully by the time we come around next week to presenting to the delegation, I would have an update with those further meetings that we're currently having.
Thank you. Seeing no further questions for this panel, thank you very much. We have a few more favorables. We have Lisa Sorrow, Matt Hill, and Albert Turner. Please.
Good afternoon, Chair, excuse me, members of the committee. I was here last week sort of previewing this bill. Why Anne Arundel County? Why does Anne Arundel County need a carve-out from
Could you tell us your name, please?
I'm so sorry. Lisa Sara with Community Legal Services. CLS provides legal services for eviction prevention in Anne Arundel County. We are in court every single day, both courthouses, whenever there is a rent docket going on. 3 of us on our team have been doing this work in Anne Arundel County for more than 20 years each. So why is this an issue for Anne Arundel County? It's an issue for Anne Arundel County because our county is the only county that follows that 5-day rule. So in our neighboring jurisdictions, from filing to trial is generally 3 to 6 weeks, maybe even longer. So the sheriff has a lot more time within which to make service in a reasonable manner so that the residents of those counties are getting notice in advance and have time, whereas in our county, they do not. So what we have been told repeatedly, as the sheriff said, it's been through administrations. It's also been through court administrations for many years. What we are told is that the judiciary in our county, they feel constrained by the statute. And the judiciary at the state level is not going to say to them, you must violate the law. Don't follow the statute. And we have a hard time making that argument to them as well. They want to follow the law. That's why this law is so necessary, so that our court can follow the law while at the same time being realistic about what the sheriff can do and being mindful of due process for the tenants and residents of Anne Arundel County. Thank you so much.
Madam Chair, Madam Vice Chair, members of the committee, my name is Matt Hill. I'm an attorney at the Public Justice Center. Public Justice Center is favorable with amendments on this bill. We thank the sponsor for bringing the bill. I just want to back up for a moment around failure to pay rent process for a second. It is the fastest nail and mail process for a court case in the state. It's actually an extraordinary benefit to landlords to have a process where you could file a complaint on day 1, and at least in Anne Arundel County, which is I think one of the only counties left, get a trial on day 5. And because of that, and because of the low filing fee, when I was working on this initially, there were about 700,000 filings in the state of Maryland each year. That was in 2019. More than the number of renter households. Now, through the good work of the General Assembly, that number has been brought down to about 350 to 400,000 filings. It's still extraordinary. It's still the most of any state in the country. The reason is it's a very fast-paced environment. It's very high stakes. You lose your home if you do not put on your defense in this case. And to have, the second point is constitutional due process. To have somebody get a filing the day before their hearing, taped to their door and find it as they're walking out the door for work is not meaningful notice and opportunity to be heard. It's not a chance to be able to say, no, I don't owe this rent, or no, I've been withholding the rent because you haven't fixed the leak in the ceiling. It's not due process, and that is critical. And so, again, in most jurisdictions where we mostly practice individual cases in Baltimore City, this used to be more of the case in Baltimore City. Now we've worked with the sheriff and have extended the time period to a certain extent. But it's still very much that we get calls from folks who say, I have court tomorrow, or I have court in 2 days. I don't know what I'm going to do. Can you help me? That's not due process. Secondly, we have the same concern that Delegate Bhandari mentioned around oversight of these folks, the civilians being deputized. And so we'd like to see more in the bill on how that oversight and training is going to work. Thank you.
Thank you. Delegate Pruski.
Yes, Lisa, I want to follow up. Thank you, and thank you to the Sheriff for bringing this bill and the sponsor. In regards to current legislation in front of the Anne Arundel County Council, isn't there a bill addressing this, or is that different?
No,
Could you please clarify, because I think
Sure.
There's some confusion about different ways to handle this.
Right.
So if you could clarify that'd be helpful.
Yeah, so I can clarify that. The bill before the county council is on the back end of evictions, and that bill is addressing the amount of time needed once a judgment is entered and a warrant of restitution is issued, so an eviction is going to occur. The county council bill would say that notice has to be given 14 days in advance of the actual eviction. So this bill is on the other end, the very beginning stage of it. So the statute right now, 8401, says that the trial shall be held 5 days after filing. That's happening in Anne Arundel County. It is not happening throughout the rest of the state. Our judiciary refuses to vary. They feel constrained by the law. Whereas in other counties, they're taking into account practical considerations of the sheriff's capabilities for service and then due process. So both, they're bookends.
Yeah, Madam Chair, just a quick follow-up if you don't mind. So to be clear, the judiciary and their interpretation is the issue here.
Well, it's not necessarily their interpretation.
Okay.
The law says 5 days.
Okay.
It is just only followed by our judiciary.
Understood.
And I just want to add to that. So Anne Arundel County Council was looking at other ways once you have been ordered with that eviction. So instead of the sheriff's department, for example, going out with these team of individuals that they have that work around the county and evicting people, physical items onto the grass or onto the curb, what this would require, based on Anne Arundel County Council, them to put a lock on the door over a period of time, and then based on if that's not resolved, then at that point, they would unlock a house, and then someone would go in and remove all the items. So it gives people a chance to recover their items over that eviction period instead of doing it from the curb. More humane.
Right. Delegate Adams.
Thank you, Chair. And Mr. Hill, just because I want to clarify, this is a local bill, and so most local bills go through with the courtesy of the legislature, provided you get support locally. So I'm only asking questions because I have some general concern that things like this pass and then they become effective for everybody else. So I've got some concern, but my only question goes to you, because you said in your testimony that the court filing can happen on day one. All right, that was your comment. It's not day one, it's day 10. Like 10 days is the 10-day notice that everybody has to give before a landlord can then file in court. So I just want to make sure we're correct on the subject, that there's notice given to the tenants on failure to pay rent. Would you agree with that?
Yes.
Okay, and so would you also agree that no sooner than day 11 after being given that notice is when somebody can actually go to court and file on the failure to pay?
To clarify my statement, yeah, so yes, I agree. And what I was trying to say is that day one is when is the filing of the complaint. But I agree that the notice has to be given on, say, day 2 after the rent's due. If the rent's due on day 1, the notice can be given on day 2, and then yes, you could file on day 11. And that, again, the notice is something the General Assembly put into place and has dramatically reduced the number of frivolous, frankly, eviction filings. And I think that the notice was critical, but just because you get a notice that the landlord thinks you're past due on the rent, I have clients who then say, well, I paid the rent. I got the notice, I paid the rent. The landlord then takes that rent and misallocates it to some sort of illegal, pet deposit that for no pet fee and claims the tenant still owes the rent. Or the tenant says, you haven't fixed the leak in the roof. I'm not paying you the rent, and they want their day in court. And so that's why that actual notice, I'm going to have a trial on X date and time to prepare, time to reach out to get an attorney, time to take off work, time to have your kids go arrange some sort of alternative childcare is so critical. And that's what's not present around the state, particularly in Anne Arundel County.
Okay, I feel like I need to press this again because I asked you whether or not it's 11 days. And the answer is you serve the notice, 10 days the tenant has before the landlord can go to court. So let me just press the other point. On that 10-day notice, do the tenants not get plenty of guidance and perhaps even free legal advice? Isn't that part of the notice? They feel like they might be having their rents misapplied and that there's a way for them to, in that 10-day notice, seek that kind of guidance and relief before the 10 days expires?
Yes, so on the notice, there is a referral, very small actually. They really need to change it to say, okay, if you want legal assistance, you can call this number.
It's the whole bottom third of the document that allows them to take the little thing and go get legal advice. I think I've got my answers, and I appreciate your clarification.
Vice Chair Charkoudian.
If I can understand your distinction, so help me out. It sounds like you're saying the notice about you're late on your rent happens on sort of day 2 after being late, and then there's 10 days to resolve that. And you're saying that's different from the time frame where you now know that your landlord has gone to court, because you may have taken action in those 10 days that you think resolve that, and now you think it's done, and now you're finding out that your landlord actually went to court the day before they're going to court. Is that sort of the distinction you're trying to make between 10 days and 5 days?
That's exactly right.
Okay, thank you.
Delegate Pippy?
It's always these additional conversations that create additional questions. Okay. So landlord and tenant have a lease. In that lease, it says if I don't receive the rent by the 5th day of the month, it's considered late, right? Or they're 30 days late, let's just say. So rent is due in August, it's now September, no rent's been paid. So the landlord posts a 10-day pay or quit notice on the door, 10 days, right? So currently in Anne Arundel, the landlord, if the payment is not received by, let's say, the 11th day, the 10 days have expired to pay or quit. The 11th day comes and goes, and your argument is that if the landlord then files a failure to pay rent claim in district court on the 12th day, that's not enough time for the tenant. Is that correct?
Well, you have to realize that if you file on the 11th day or the 12th day, whatever it is, first, no landlords that I know of, responsible landlords, are waiting 30 days past when the rent's due. They're generally sending that notice that the rent hasn't been paid on day 2.
But no, but you keep saying day 2. You mean after the 10-day period?
No, I'm not. I apologize, Delia. I didn't mean to cut you off. Go ahead.
So are you saying they are filing, and this is good, are you saying they're in Anne Arundel County, a landlord is filing the complaint before posting the 10-day notice?
No, Delegate. Again, the rent's due on day 1. The landlord sends a 10-day notice on day 2.
Yeah, posted on their door.
Posted on the door. And then, again, if the landlord feels they still haven't been paid, they wait the 10 days, and then they can file a failure to pay rent complaint in court on day 11 or 12. And then in Anne Arundel County, at least, unlike most any other jurisdiction in the state, they have a trial on the 5th day after filing the complaint. The tenant doesn't get that complaint. It's not served by the sheriff until oftentimes, from what I understand from Ms. Sorrow, the night before the hearing, the day of the hearing. And that's our concern, is that's not due process. That's
Well,
not a
Baltimore
chance.
City has a rule where it's 7 days.
In Baltimore City, the practice right now is from filing of the complaint to the trial is at least 9 or 10 days. And that's because the sheriff in that county has said to the court, look, that if we don't have at least the time to properly serve the tenant, that's not constitutional due process.
So the rule in Baltimore City is 7 days. So if it's not.
No, that's.
Come again?
Sorry, that's not what I said, Delegate. I said that.
No, I'm telling you what it is.
Oh, okay.
Yeah, it's 7 days. 7 days. If it's not posted on the property 7 or more days prior to the court date, the judge doesn't let the procedure to go through. That's in Baltimore City. But that's not what I'm getting at. I just want to find out when someone. What's that?
I apologize, Delegate. I'm just not familiar with that rule.
I'm not either.
Do you practice in Baltimore City?
I do, yes.
Okay. So the question is that I have is if you file the complaint in MDEC or wherever on the 12th day, you're saying that the court hearing is held when in Anne Arundel? How quick from when I file on the 12th day is there a court date scheduled?
I can answer that
Yeah.
for you, bringing it back to the Anne Arundel specific bill that we have here. The hearing will be scheduled 5 business days later, period.
So they're automatically, the clerks are scheduling it 5 days later, no matter what?
Which is what is it's required by the statewide statute. The practice throughout the rest of the state is not to follow that because they cannot. They cannot. Our judiciary is placing incredible pressure on the Sheriff's Department, and tenants are not getting due process because the judiciary is following the law in our county only. That's why this bill is necessary for our county, so that our judiciary can do what they want to do, which is follow the law, and tenants can receive due process, and the Sheriff's Department is not overwhelmed with 5 days a week service of hundreds of complaints on an emergency basis because they have to be done so quickly. That's why this is a county-specific bill. This is a county-specific problem. It will not change any practices outside of our county. It will just bring Anne Arundel County into line with what's going on, the practices in the other counties in the state.
Okay.
It brings fairness to our county.
Thank you.
Delegate Ahrens.
Thank you, Madam Chair. Got it right this time. I guess my thought, based on some of what Delegate Pippi was saying, you're assuming that the rent is due, the 5th day is, after the 5th day, it's late. Is that right? We agree on that. After the 5th day, it's late.
Most landlords take the position that the rent is due on day 1 and late on day 2, and that they graciously waive the late fee if it's paid by day 5 or day 10, depending on the county and the lease.
Okay, I think where I'm getting confused is you're making this statement that landlords do it, the rent's due on the 1st, they do this on the 2nd.
They send the notice of intent to file on the 2nd, yes.
Okay, and that's not normal in my world, okay? My tenants, you have a date of the 5th, after the 5th, I can attach, blah, blah, blah. So the assumption is this isn't the first time the rent's been late then?
I don't understand.
Well, I mean, if you miss a date, if you're my tenant and it becomes the 1st, I promise you, I'm not coming to you and taking you to court on the 2nd. I'm not filing against you on the 2nd, I promise you, if that's the first time you've been late.
We have many landlords who will send you the notice
So
on day 2.
that's what's happening in Arundel County. If your rent is due on the 1st, you've got a 5-day grace period. On the 2nd, you're filing papers against that person.
Well, filing papers meaning, I'm sorry, go ahead, Lisa.
Oh, no, I was just going to say, for Anne Arundel County, the 10-day notice is just a notice that you intend to do something in the future. We are seeing those notices go out, not just in Anne Arundel County, but throughout the state. Those notices are going out often the day after the rent is due, pretty much for everyone, so that landlords are in a position to file on the 12th day after rent is late, on the 12th of the month. I also wanted to say, just for clarification of like the filing date, the trial and judgment and service, I attached to my testimony several complaints that have a judgment. So on those complaints, you'll see the filing date, you'll see the service date, and you'll see the judgment date. So you will see that there's 5 business days from filing to trial, and then 1 day from service to judgment. So, and that's a regular occurrence. Every single day, tons of default judgments because people are not getting served.
Again, I apologize, I'm giving you my experience on this. When somebody's late with me, if they're late the first time, that's okay. I can wait till the 5th day. I don't file that way. That's not the way I run my business. I don't have to run my business that way. What I'm asking is, obviously, if there's no grace period like that. If it's that hard line and I want to get rid of a tenant that bad because I want to keep my tenant because it costs me money to rent that place. Am I right? So I'm not looking to get rid of somebody because they're a day late. I'm not looking to get somebody based on the first. I give them a grace period.
Delegate, I appreciate the question. This bill is about the Anne Arundel County specific Sheriff's Department and the actions that they're requesting to take on behalf of their department so that they can execute the responsibilities of the court when dealing with tack-ups here in Anne Arundel County. We are looking for that bill specific to what's taking place here in Anne Arundel County.
I got you. I guess I was going back on something we talked earlier. Maybe there's a better way around this. But
I appreciate it.
Thank you
Thank
very much. I'll let it go.
Delegate Johnson.
Thank you, Madam Chair. I just want to put a lid on this conversation. The question I have is that, because I'm no fluff, right? So the question I have is for this bill is does this procedurally create fairness for everyone across the board?
In what capacity?
As far as the Sheriff's Department being able to tack them up, for the person that's getting evicted, for the person that owns the home that's running the home, is it fair across the board for everyone?
Absolutely. The intent of the bill is to be fair and equitable to the residents of Anne Arundel County.
Thank you very much.
Seeing no additional questions for this panel, thank you very much. I had called on an Albert Turner. Is he here?
He is with me, Your Honor, is a colleague of mine. He will not be testifying.
Okay, thank you very much.
Thank you.
Thank you. Then that concludes the hearing on House Bill 62. We'll now move on to House Bill 153. Delegate Lehman.
Did you call me, Madam Chair?
Yes.
Okay, I thought there was opposition testimony. Can I call my, I'm sorry.
I'm sorry, I'm sorry, Delegate Lehman, we had an opposition. My apologies. Members, we have Matthew Pipkin on the unfavorable.
Excuse me. All right. Good afternoon, members of the committee. For the record, my name is Matt Pipkin. I'm here on behalf of the Maryland Multi-Housing Association. My background prior to my role with this for the last 2 years, I also worked with the Maryland Judiciary. I was one of 3 government affairs professionals there. Before that, I served for 4 years on the Anne Arundel County Council as a legislative aide, so I feel uniquely qualified to talk about this. You have my written testimony. I think I'm going to go off script a lot. I believe my colleague from the Public Justice Center said it correctly. The sheriff is certainly able to work with the administrative judge in his jurisdiction to overcome these issues. He said so in Baltimore City. This statute that you see before you is the same across the state. And we have not heard from anywhere else of this issue occurring. Now, I don't know if that's because there just hasn't been a discussion between the administrative judge of the district court in Anne Arundel County and the sheriff. I don't know if, again, it could be a funding concern, but at the end of the day, this is all going to come back on the housing providers. There's no write-offs when it comes to this. The write-off will be an increase in rent because delinquency rates are going up. I mean, that's just how it's going to happen. That's exactly what's going to happen with this bill. And I will tell you, failure to pay rent actions are going down in Anne Arundel County. From the best data that we have, it's down 14.4% in the last 2 years. And to talk about Anne Arundel County Council Bill 10125, my point with that is that bill will reduce the workload already with the sheriff. So the sheriff's workload is going down. It's going to go down even further with the workload from the local bill that's going to happen. And again, this extending the eviction process arbitrarily like this will just raise rents. You know, setting it 30 days after filing of the complaint and cap the number of failure to pay rents that can be heard on that day in court to 100. I mean, right now in the county, it takes about 2 months to do a full eviction in Anne Arundel County. This will probably make it closer to 3 overnight.
Thank you. I don't see any questions from the members. Thank you very much. Now this concludes the hearing on House Bill 62, and now we will move on to House Bill 153, Delegate Lehman.
Thank you, Madam Chair. Can I bring up my panel of Zephyr Shaw and Matt Hill? Thank you. Good afternoon, Chair Valderrama, Vice Chair Charkoudian, and esteemed members of the Economic Matters Committee. For the record, I am Delegate Barry Lehman, asking for a favorable report on HB 153, which establishes air conditioning requirements for residential rental apartments. I realize housing is new for this committee, but many of you actually voted for this bill on the House floor in 2025. The 2026 bill is the House-passed 2025 bill. So this legislation requires the provision of air conditioning in rental units in newly constructed apartment buildings with 4 or more units, as well as in existing rental units that undergo substantial renovations that include the replacement or substantial upgrade of electrical systems or existing heating systems. So in these cases, the air conditioning must be capable of cooling each unit to no greater than 80 degrees Fahrenheit. If that seems high to you, I am open to lowering that temperature. That actually is the threshold temperature required in both Prince George's and Montgomery counties, which I will remind you, the 2 largest counties in the state represent 1/3 of Maryland's population. The air conditioning requirement applies between June 1st and September 30th, and the type of air conditioning installed is left up to the property owners. That could be heat pumps, it could be central air, it could be window units, as long as the unit can be cooled to that 80-degree threshold. So this version of this bill is the result of hard work and compromise with groups including the Maryland Multi-Housing Association and the Apartment and Office Building Association of Metropolitan Washington. I am asking that you consider this bill not only in the context of housing and renters' rights, but also as a matter of public health and disaster mitigation. Just since I brought this bill before the House last session, heat-related cases of emergencies are rising across the state, including ER visits and deaths. All of the following statistics that I am about to recite come from the 2025 Maryland Department of Health Heat Report. So from 2024 to 2025, there was a jump in heat-related ER visits from 1,255 to 1,674. This increase is applicable to all demographics and most locations across the state. There were 34 heat-related deaths in the state last year. That is a record, and it's a 26% increase from the previous year. Increases in deaths were recorded across the state, yes, even in the far reaches of Allegheny and Washington counties. Heat also does not discriminate by age. We saw increases in both hospital visits and deaths among children ages 0 to 17, adults ages 65 to 74, and then adults age 75 and older. And lastly, 53% of those heat-related deaths actually happened indoors, so 18 of the 34. The 2025 report states that during extreme heat, people need access to air conditioning spaces. The bill helps to do that by bringing air conditioning into more Marylanders' homes. So there is a lesson to be learned from a deadly 2021 Pacific Northwest heat wave, which killed 200 people, including 69 in Multnomah County, Oregon. A follow-up study found that only 3 of those who died had working air conditioning, and that lack of air conditioning was a key driver of mortality. 2 years ago, the Senate Judicial Proceedings Committee, along with my former committee, the Environment Transportation Committee, passed the Tenant Safety Act of 2024, providing much-needed protections for tenants living in unsafe housing conditions. However, state law still does not address cooling requirements, nor does it set a maximum indoor temperature for what can be considered habitable housing. Because of that, as you will hear from my panelists, legal action in extreme heat situations remains an uphill battle unless cooling is specifically added in a tenant's lease. This proposal is a first step toward changing that. I'm confident that it will save lives. So I ask for a favorable report, and I thank you for listening.
Chair Valderrama, Vice Chair Charkouti, and members of the committee, I'm Zephyr Shaw, Advocacy Director for the Human Right to Housing at Maryland Legal Aid. This bill, if you are a low-income senior renter or a person with disabilities in a multifamily rental building, might be one of the most important bills before the session. And I say that based on my experiences with clients over this past summer. Over 15 clients under the Tenant Safety Act came together and filed a lawsuit against their multifamily landlord because their building, though only 15 years old, has not had a working HVAC for years. And so for the past several years and the increasing heat that Delegate Lehman just mentioned, they've had no recourse. And so they filed a lawsuit, and this is what's really interesting for you. The court found that they had not stated a claim because it was not a threat to health and safety under the law because we don't have that 80-degree Fahrenheit threshold outside of Montgomery and Prince George's. And so even though we had an expert testimony from Johns Hopkins, a public health expert, to testify about the effect of lack of heat in that building, and all the tenants could have told all the health problems and not just inconvenience, but disturbing conditions because of their lack of mobility. The court found that the court itself had their hands tied by the lack of this standard. So we urge this committee to once again, as the House did last year, pass this bill. But we do seek a favorable report with amendments to address the fact that there are properties with existing HVAC, with the wiring, with the system in place that are not being held to the 80-degree threshold simply because of a loophole in law. Thank you.
Madam Chair, Madam Vice Chair, members of the committee, again, my name is Matt Hill. I'm with the Public Justice Center. We also strongly support the bill. We thank Delegate Lehman for her relentless leadership on this issue over a few years. I would only be echoing a lot of what Mr. Shaw testified to, in that his experience is not unique. We all the time have tenants calling us, calling my colleagues in the middle of summer when it's 95 degrees. And these are folks who are seniors, folks with disabilities, folks who have serious health conditions. And the air conditioner is broken. And I have to, and my colleagues have to be the one to tell them, well, we don't know. That's not really covered under the Maryland rent escrow statute. But maybe it is, but I don't know, because we might get a judge who says that there's no way to make that a threat to your life, health, and safety. And so this is really about setting the floor for what's foundational. And 80 degrees, in my opinion, is too high. I don't know if any of us here have our thermostat set to 80 degrees, especially if we're a senior or a person with a disability. But it is too high. But nonetheless, this is an incredible foundational bill, and we hope that local jurisdictions can build on this bill. And so the one amendment we'd ask for is just clarification. We think that this is a floor that local jurisdictions can build on. We'd like an amendment to clarify this is the floor, and if a local jurisdiction wants to set it to 75 degrees, or they want to include their housing authority, as Baltimore City should, then that would be something that they could do in the future. So thank you.
Thank you. We'll start with Delegate Weigel.
Madam Chair. Hello, Delegate.
Hello.
A question on some of your statistics. You made a comment about which counties have the largest populations.
Yeah, across the state, and I mentioned Washington and Allegheny specifically, that there were deaths recorded in those
No,
counties.
you said the largest populations. What?
I was referring to the law that's on the books in Montgomery and Prince George's. Those are the two largest jurisdictions, and together are home to 1/3 of Maryland's population.
So they already have this requirement?
They do have this law. It's specific during the hottest months of the year, the summer months, and it has that 80-degree threshold we talked about, which I agree with Mr. Hill is too high.
Okay. And then the statistics you talked about on the heat-related deaths, you said 18 of the 34 happened indoors. How many of those were rental properties of the 18?
There is no breakout done by this heat study. We only know that 53% of the deaths happened indoors versus outdoors.
Okay. It'd be nice if we had that information. All right, thank you.
I can certainly inquire about that because someone else did ask me that question. So
Okay.
thank you, Delegate
All right,
Weigel.
thanks.
Delegate Ahrens.
On the landlord side of this, how does it work for them? Because putting in an air conditioning system in a unit doesn't have it, could get expensive. Does this affect, do you have any thoughts on how this might affect the lease and what the recourse is for a landlord who's going to be putting a lot of money out?
I mean, Delegate, my understanding of this bill is it only is applying to new construction or when there's already a substantial rehab. So the idea is, and this is why it's, again, a floor and it's just foundational, it's much more work to do. But if the landlord's going to put in the money to do a very substantial rehab, then air conditioning in an era of climate change should be included in that rehab.
Okay, I'm sorry, I misunderstood it. Thanks.
Delegate Adams.
Thank you, Chair. Only in follow-up to that question, so the bill language says that that beginning on October 1st, 2026, for residential rental units that undergo renovation that include replacement or substantial upgrade of electrical systems or heating systems. My only question would be, what's the definition of substantial upgrade? In other words, I hate to be reading words for legislative intent, but I guess I need to understand what your legislative intent is to.
So that, I will attempt that. That is an issue that we've looked at in this bill over the last 2 years, sought input from a lot of different housing experts that had, differing opinions on whether to tie that to a dollar threshold, dollar per square foot threshold, or a total system threshold. And the first year I think I had the bill drafted, the drafter looked in Maryland law and said that there was only one definition of a substantial renovation, which clearly is outdated, which defined it as a renovation that was $10,000, a minimum threshold of $10,000, and that didn't seem adequate. So we went with this language around like a complete replacement of an electrical system or a substantial upgrade. And I am open to additional ideas on that, but we could not get to any different place, and we sought many, many opinions on that.
And where's the part of the bill that says that the compliance could happen through the lens of a window unit?
I don't understand your question.
Well, you were saying that you could, a landlord could comply with the law by putting in a window unit. You don't necessarily need to spend $18,000 on a new HVAC system. I thought that was in the sponsor testimony, I'm sorry.
As long as the temperature can get down to 80 degrees.
Okay, you don't care how it gets done, it's a temperature requirement.
And I did comment, just to clarify, so it's 80 degrees, 3 feet above the floor, and there was a comment, I don't know if that's what you're referring to in my testimony, saying the bill is intentionally not prescriptive about the type of air conditioning. It could be window units, it could be a heat pump, it could be central air. But that threshold of 80 degrees, 3 feet above the floor is, again, what's in Montgomery and Prince George's County law.
Delegate Amprey.
Thank you, Madam Chair. And again, I love the spirit of this bill. Just for me, any bill like this, I'm all about how do you enforce it. So just want to understand, and maybe you can give me, you said earlier the example of in Montgomery County and Prince George's County, how do you do that whole 3 feet measurement? What does that look like? Because I'm trying to understand, because what I want to make sure is that if we're going to have this be a statewide law, that if individuals are going to enforce it, I want it to be enforceable. Your rules are only as good as how well you can enforce them. So I just want to understand, how is it currently enforced in Prince George's County and Montgomery County? Do you have any examples of when a landlord has run afoul, and how do they measure and make sure that that 3 feet, 80 degrees threshold was done properly?
No, thank you, Delegate Ampry. That's a great question. I believe you are the chair of the Housing Subcommittee, so glad you asked that. So all I can tell you is that, first of all, like a lot of similar laws, this is going to be enforced at the local level, and it will be complaint driven. When I was on the Prince George's County Council, I had a friend at that time who lived in the city of Greenbelt, and in a high-rise apartment building where the landlord often failed to turn on the air conditioning during those specified months that are in the law, the summer months. And in that case, it was the city of Greenbelt, because it was a municipality that would go out and check the average temperature and check, to find out and interact with the property manager about, why isn't the air conditioning on yet? So, and I would welcome my witnesses here to
If I may, I
weigh
would
in.
just add, Delegate Ampry, that I believe, and I will double check for you, that the heating standard is much the same in Baltimore City. There's a 3-foot check, and we've seen that the code enforcement inspectors for the Department of Housing in Baltimore City bring their equipment to do that with, I believe it's like an infrared type of measurement. And they would go room to room as required. Currently, the Department of Housing code enforcement inspectors do cite a violation for failure to maintain mechanical equipment, but they can't cite a violation for the actual cooling, the failure to cool itself. But I would expect, just my expectation, having done this work in Baltimore City, is that with this standard provided and under this law, those inspectors would be equipped to enforce it.
Seeing no additional questions, thank you very much, Delegate Lehman.
Thank you.
We'll now move to the opposition. Bill Castelli.
Thank you, Madam Chair, members of the committee. Bill Castelli on behalf of the Maryland Realtors. And our position is probably better described as undetermined. We've had some good conversations with the sponsor of the bill, as well as some of our colleagues who have experience with the law in Montgomery and Prince George's. So we are taking the bill back for reconsideration. They've been able to answer a lot of the concerns that our members had.
Oh, well, okay, great. Delegate Adams has a question for the undetermined.
So it's informational testimony is what you're saying?
Well, so yes, it was testimony before we were able to have conversations with some folks,
So in the day and age of energy bills being what they are and tenants stressed over energy expenses, one of the things that they do is turn off systems that are too expensive to run. And so my question goes to, at what point does a tenant have the responsibility to use systems that are in place, whether it's a window unit or a central HVAC, and they're not willing to run the system, causes the fault? How do you, or do you have an opinion on that? How do you reconcile
the way
compliance?
our conversations, the way we've understand it is that whether they choose to use it or not, and then file a complaint, the code official would still come out and run the system. So as long as the system works to cool it, they would just verify that the system is working, and then it would be, that would be proof that they have a system that works and does it, regardless of whether the tenant turned it on.
So the complaint-based part of this is more than just a complaint. There's a code
Inspection, yes.
inspection part of that. Okay, all right.
Yep.
Okay, I think I'll stop there. Thanks.
Okay.
You sure, Delegate Adams? Okay. Seeing no further questions, thank you very much. That concludes, oh, I'm sorry. Delegate Weigel has a question. Mr. Castelli?
So in regards to the inspections, who pays for those?
That would be housing inspector, so whoever is.
And so they don't bill the landlord for those inspections?
It's a good question. I don't believe so.
Okay. All right, thank you.
Making sure no one else, okay. Seeing that, that's the, concludes the hearing for House Bill 153. We'll now move on to House Bill 200, also Delegate Lehman.
Thank you, and again, good afternoon, Chair Valderrama, Vice Chair Charkoudian, and members of the Economic Matters Committee. For the record, Delegate Mary Lehman, asking for your favorable consideration of House Bill 200, Flood Risk Disclosure. This bill protects sellers and potential buyers of residential real estate through disclosure of a property's flood risk. Beginning July 1st of 2027, a seller of residential property must disclose specific flood risk information to the purchaser prior to entering into a contract. The flood risk disclosure form will be developed and published by the Maryland Department of Environment. This disclosure would include whether the property is within a designated special flood hazard area, which means it has a 1% annual chance of flooding, or a moderate risk flood hazard area, meaning it has a 0.2% annual chance of flooding. Whether federal law requires insurance on the property, whether the owner has flood insurance on the property, whether the seller has received any financial compensation from a federal agency for flood damage, and whether the seller has knowledge of flood damage caused by a variety of sources that would include heavy rainfall, coastal storm surge, tidal inundation, or river overflows. According to FEMA, 1 inch of floodwater can cause up to $25,000 in damage, which can be crippling for many homeowners. The bill does not require Maryland residents to purchase flood insurance, but it could drive them to do so. As climate change continues to make extreme weather events and catastrophic flooding more common, the bill will protect Marylanders and provide an extra level of emergency readiness across the state. Flood disclosure laws have been adopted in 30 U.S. states. Maryland is obviously not one of them. A flood disclosure policy in Maryland is important with its unusual geography. As you all know, in addition to the Atlantic coastline, Maryland is home to the Chesapeake Bay, which has 11,684 miles of shoreline with all of its tributaries. According to our Department of Natural Resources, the Maryland coastal zone extends from 3 miles out into the Atlantic Ocean to the inland boundaries of 16 counties plus Baltimore City that border the Atlantic Ocean, the Chesapeake Bay, and the Potomac River to the District of Columbia. That area encompasses a staggering 2/3 of our state's land area, and it actually is home to 70% of all Maryland residents. This flood disclosure policy is good for Maryland, and I respectfully ask for your favorable report. Thank you.
Good afternoon, Chair Valderrama, Vice Chair Charkoudian, and members of the committee. My name is Hamna Sharif, and I'm representing the Nature Conservancy's Maryland DC chapter. In Maryland, our work focuses on delivering clean air, clean water, and healthy and secure living environments for Maryland's ecosystems and residents. The Nature Conservancy supports HB 200. As mentioned by Delegate Lehman, our state is facing a climate crisis, and it often manifests in the form of flooding across our coastline and across our riverine corridors. Last year, Western Maryland counties saw devastating floods in Allegheny and Garrett counties. This bill brings much-needed transparency to Maryland's flood disclosure laws and includes FEMA floodplain indicators, which are important federal metrics to be able to tell how high of a risk a property is. It protects both buyers and sellers, and when purchasing a property, home buyers are often left unaware of the flood risk that they face, which is potentially life-endangering information and also saddles them with high costs of repairs after a flood. HB 200 aims to fix this gap in policy and brings much needed information to our state agencies to also allow them to be able to deliver better flood resilience programs. Therefore, we urge a favorable report, and thank you for your consideration.
Chair Valderrama, Vice Chair Chargoutian, and members of the committee, thank you for this opportunity. My name is Joel Scata. I'm a senior attorney at the Natural Resources Defense Council, and I'm here to urge your support for HB 200. Maryland faces a growing flood crisis. The state's extensive coastlines make it vulnerable to storm surges and sea level rise, which could increase by 1.5 feet by 2050. High tide flooding in Annapolis alone could reach up to 155 days per year by then. But here's what's alarming. When Marylanders buy a home, typically their largest financial investment, they're kept in the dark about flood history. A recent study found that buyers of previously flooded homes in Maryland can expect to pay $65,000 in flood damages over the course of a 30-year mortgage. Currently, Maryland only requires sellers to disclose if a property is in a flood zone, or only explicitly requires disclosure in a flood zone. That's not enough. FEMA maps are often outdated, and 40% of flood insurance claims actually occur outside FEMA-designated flood zones. And that's why NRDC gave Maryland a D grade for the quality of its flood disclosure law. HB 200 is straightforward. It requires sellers to disclose what they know about a property's flood history, past damages, insurance requirements, federal aid received, and any flooding that the property has experienced. This isn't radical. Since 2018, 10 states have strengthened their flood disclosure laws. A nationwide survey shows that 74% of Americans support these requirements. HB 200 would move Maryland from a D grade to an A grade, joining states like North Carolina, South Carolina, Texas, and Louisiana. It gives homebuyers the information they need to protect themselves and their families and their investment. Buying a home is the biggest financial decision most people make. Without crucial flood risk information, Maryland homebuyers are vulnerable to devastating financial loss. Please support HB 200 and ensure future homeowners have the knowledge they need to protect themselves from the growing threat of flooding. Thank you.
Thank you. Delegate Queen.
Madam Chair, mine's a quick question, and you started to talk about some of the states that have good grades on this. Does this bill model any of those states like Texas, North Carolina, New Orleans, and Mississippi?
Yes, so this bill models laws in New York, New Jersey that have very strong flood disclosure history, flood disclosure requirements. It also would be similar to laws in New York, I already said New York, North Carolina, South Carolina, Texas, and Louisiana, which all have very strong disclosures.
That's it.
Delegate Weigel.
Thank you, Madam Chair. Just a question on the FEMA maps. You said they were greatly outdated.
Yes.
So how often are they updated?
By law, they're required to be updated every 5 years, but they often fall far short of that. The Inspector General for the Department of Homeland Security about 7 years ago did an inspection and found that a lot of the maps could even be upwards of like 20 years out of date because they're not updated enough.
But this bill references the FEMA maps.
Right, so this bill references the FEMA maps because it's a legal reference for how you can judge if you're in a flood zone, but it also goes well beyond just determining whether you're in a flood zone. Maryland law already requires to tell a seller or to tell a buyer whether you're in a flood zone. This would also then require if the property's already been flooded, that the buyer learn about that, or if there's a mandatory insurance requirement, that the buyer be informed about that.
So I know you referenced Western Maryland, the flood they had up there. So under the requirements of this bill, you would have to reference a flood that occurred in how many years past, within how many years, or just if it ever occurred, you'd have to mention it?
So the bill's two main disclosure requirements are about the history of that property, specifically the flooding history on that property, and then the...
So how far back does that history require?
I don't believe
it would be limited to the actual knowledge of the seller.
Of the seller, right. It doesn't, it's not date specific, but it's the knowledge
So it would just be one
the
of those
seller.
disclosures
Possibly the
where the
Maryland
seller says,
realtors
"We're
who
not
are here
aware
can
of-"
answer that.
They would check a box, they're not aware of any flooding?
That's my understanding, yes. If they were unaware of any flooding or had no actual knowledge of flooding, then they wouldn't be responsible.
Okay, thank you.
Delegate Adams. There are no further questions from this panel. Thank you. We have Bill Costelli.
Thank you, Madam Chair, members of the committee. Bill Castelli on behalf of the Maryland Realtors. And we support the legislation with specific amendments to address a couple issues. First issue is making sure that this disclosure operates the way the seller disclosure form currently operates. The seller disclosure form is widely used in the real estate. It has certain exceptions. Those exceptions mostly apply to sales where you don't have a seller who's going to be able to attest to what has happened on the property. Might be an estate sale, might be a fiduciary who's selling the property on behalf of family members. So in instances where you have some of those types of transactions, it would exempt those like every other seller disclosure transaction has. The second change that we're looking to do is the way the bill is laid out. It has the form that you would fill out that it would be created by the Maryland Department of Environment, and we don't have a problem with that. Sellers will have knowledge of that, including it's fairly easy to find out whether your property is in one of those areas. There's a website. You can type in your address. It pulls up a map on your property. So it's a fairly easy process for sellers to do. But we do want to make sure that when they're giving this form, the second part of that bill also says they've got to give any kind of records of payment that they used on flood insurance. I mean, these could be flooding events that happened 20 years ago. It'd be very difficult for a seller to kind of provide any of that information. So we think as long as they're giving the form as well as, if available, the FEMA elevation certificate, that should be sufficient in terms of making sure that buyer has notice of what they're getting into. The buyer's also going to get notice, from the title company, the mortgage company. They'll probably get a clue report. So there's other information that buyer's going to get as well.
So these amendments that you're proposing, has this been a conversation also taking place with the bill sponsor?
Yes, we've shared them with the bill sponsor, and we are in ongoing conversation. Yeah.
Okay. Delegate Ahrens.
Thank you, Madam Chair. You're having discussions. They're not part of the bill now. They're not agreed upon.
Correct.
Okay. Are you going to do a new disclosure for the realtors? Is this going to be a separate piece?
This would be a separate form developed by MDE. So, in fact, one of the things we had spoken to the delegate about before was doing a delayed effective date as well, which is why you have the July 1st, 27 date. That would give us plenty of time to make sure members are familiar with the processes, where they would get any of the information to look up, to advise sellers on how they can easily check on their property, and then give us enough time to make sure we've got the form and make any changes to the contract that we need to do.
Okay. Will you keep us informed of whether the amendments are accepted?
Yes.
Okay. All right. Thank you. Thank you very much.
See no further question. Delegate Lehman, did you?
Madam Chair, if I could, and thank you,
Yes.
Mr. Costelli. I am continuing to work with the realtors, and I do consider the amendments that Mr. Costelli described as friendly amendments.
Thank you very much. Is that good, Delegate Ahrens? Seeing no further questions, thank you very much. This concludes the bill hearing on House Bill 200. We'll now move on. Who's been waiting very patiently? House Bill 168. Delegate Vogel, you want to bring your panel up?
That is educator workforce or rental?
8, your housing and community development, affordable housing?
Educator, yes. Madam Chair, Madam Vice Chair, committee members, here with House Bill 168. I have a dream team panel here that can share more about the problem at hand and the solutions that we are putting forth in this legislation. Educator recruitment and retention is an issue of critical importance to our state right now. We know we are still short approximately 1,000 educators across the state. And one of the barriers both to entry and to educators being able to stay on the job is access to housing, housing that they can afford, especially for those educators early on in their career. Ideally, right, educators should be able to live in the communities that they work, but oftentimes that is just impossible given the cost of housing in those communities. What this legislation does is make a number of different changes, to promote and incentivize the construction and development of educator housing across the state. First, we make changes to the definitions around light tech and what qualifies for light tech funding to make housing for educators eligible for that funding. Second is we clarify that housing is an option for what school districts can have as their development on their property, allowing them to retain their property status even if they're constructing housing, which would lower the cost of constructing that housing. We also make changes to the Housing Innovation Pilot Program to add educator workforce housing as part of what they can invest in. That was a program that was created recently in the last few years by the General Assembly, so we're slightly expanding their scope. And lastly, we make changes to a fund focused on community development to allow for folks that want to invest in communities to get tax benefit, but we make it so that investments in educator workforce housing through that program are also eligible for those tax incentives. With that, I will turn it over to the rest of the panel here to share more about why this issue is so important and the solutions that we're coming up with on the ground in our municipalities and school systems. With that, I urge a favorable report on House Bill 168.
Good afternoon, Chair Valderrama and members of the House Economic Matters Committee. I am Monique Ashton, Mayor of Rockville, and I thank you for the opportunity. On behalf of the city, I want to thank Delegate Rogel for sponsoring this important legislation. We were touring and going around potential projects in Rockville and realized we wanted to do something special for teachers because we do have this teacher shortage. And there was nothing in place that we could really do this kind of work. And so we think this bill is absolutely necessary. The Mayor and Council of Rockville unanimously support HB 168. The bill strengthens the ability to produce and finance affordable housing designated for teachers and local system employees by making educated workforce housing an eligible use with the Maryland Department of Housing and Community Development financing tools, by expanding eligibility for the Housing Innovation Fund, the Housing Innovation Pilot Program, to include municipal corporations and county boards of education. The bill also adds educated workforce housing as an allowable project type under the Neighborhood and Community Assistance Program. Rockville schools, like schools across the country, are competing for staff and to choose the honorable profession of educating our children. There are nearly 1,000 teacher vacancies in Maryland, and there are teachers in Rockville who are traveling more than an hour to get to their jobs and get there early. That's not fair. When educators can't live near the communities they serve, districts face higher turnover vacancy rates, longer commutes that reduce retention, and difficulty recruiting early career teachers, which we know are so important. The Stanford Center for Education Policy Analysis found that higher teacher turnover disrupts learning for students, leads to lower academic achievement in math and English, and particularly high poverty schools. Students experience decreased continuity of instruction, increased behavioral issues, reduced emotional stability. House Bill 168 addresses this by aligning housing finance tools with workforce reality and opening a practical path to develop housing through public land partnerships and innovative finance. Thank you very much.
Good afternoon, Chair Valderrama, Vice Chair Charkoudian, and members of the committee. My name is Paul Lemley. I'm a National Board Certified Social Studies teacher and president of the Maryland State Education Association, representing 76,000 educators and school employees across Maryland. We're here today in strong support of House Bill 168. What this bill really does, of course, is make life a little bit more manageable for our teachers and school employees. Right now, too many educators cannot afford to live in the communities where they work. We face long commutes, rising costs, and impossible economics that push too many of us out of the profession altogether. If you're not keeping up with MSDE data, about 50% of all teachers leave the profession in their first 5 years, and with the most of those teachers being Black and Hispanic teachers quitting at the highest rates. House Bill 168 helps change that by recognizing educators as a priority for affordable housing, by making teachers eligible under federal housing incentives, especially the low-income housing tax credit. This bill helps bring together public and private investment to create housing that educators can afford, often near the schools where we work. This means shorter commutes, more stability, and stronger connections between schools and the communities we serve. When educators can live where we teach, we stay longer, engage more deeply, and better support students and families. I'm picturing writing that letter of recommendation for the student in the place where I shop. Strong schools depend on a stable workforce. House Bill 168 supports both. We respectfully urge a favorable report. Thank you.
Thank you. Start with Delegate Shi.
Hello, it's so good to see you, Mayor Ashton, and our colleague from Montgomery County, Delegate Vogel, who always has such a great supply of ideas. I love the idea. I just want to make sure I understand how this could actually work. And I was reading DHCD's letter about this. So first of all, if the delegate could explain how this or similar programs like that have worked elsewhere, because we're talking about the federal program administered by the state, right? So has it worked in other places that we're trying to emulate? And also, if you could speak to whether this would, because DHCD said now they have to, with this bill, they would have to change their procedure and all of that, about which projects or programs qualify, right? So please speak to the competition for that kind of pot of money, you know, if we expand and make this eligible.
Thank you, Delegate. When I first did my initial remarks, I was missing my folder. Now I have it, so I'm ready for your question.
You have the data.
In terms of existing programs, I should note that there are existing models of educator housing in the state of Maryland. Rebuild Metro Baltimore has a phenomenal model. We met with them over the summer together with Mayor Ashton and learned about what they were doing and some of the barriers that they ran into. This legislation seeks to address some of those barriers and make it easier to replicate programs like it across the state. A number of states, California most notably, have passed legislation changing some of these regulations that we're proposing to change here. This bill is not going to build educator housing, right? We're not looking to fund the construction of just, a bunch of educator housing. We're looking to make it easier for developers and school systems and municipalities to come together and build it, right? The changes here, there's a number of changes specifically, right? One is making it clear that workforce housing is a school purpose. That provides for school districts to retain their, tax exempt status on land, making it more affordable to build housing there, which helps lower the cost. What we saw in what Rebuild Metro Baltimore is doing is, they construct the building and then they use I believe that's the Neighborhood and Community Assistance Program, which folks can contribute to. They use that to offset the cost of the rent for every educator. So what this bill does is create an incentive for folks to contribute to those funds to then help offset the cost of the rent. And then lastly, we are making some changes, which is what which DHCD discusses in their letter of information, to these federal programs that are administered in the state. It's in line with what California did to consider educator workforce housing as eligible for light tech assistance. And lastly, it is adding educator workforce housing as one of the as one of the eligible uses of funds through the Housing Innovation Fund program. So really it's about incentivizing and making it easier to have these sorts of projects across the state. Yeah.
Just want to add a practical example. You have some school systems that have land that's not being used or it's dilapidated, and they might want to consider things to help make their district more attractive to hire teachers, and there isn't a mechanism that they could partner in a way to make sure that their teachers would be taken care of. And so this is something at a practical level that we were coming up against and met with Delegate Vogel to say, what kind of solutions can we work on? What innovative models are happening in other states? And this was the best path forward.
And just quickly to add a very clear example of what we're seeing in Rockville, Delegate Chi, I'm happy to go look at it with you. It's probably 10 minutes away from your house. It's on 355, basically across from Rockville Town Center. You have where all of the warehouses have been for MCPS, that they've now moved to the city of Gaithersburg, and now you have very old vacant properties that, they should have been. We should have moved those facilities somewhere else a long time ago, right? We visited those facilities over the summer. But what are they going to do with that land? There is the opportunity there to construct educator workforce housing. This bill would make it easier to do that.
You're good. Delegate Weibel.
Thank you, Madam Chair. Just a question. The language says teachers and other employees of a local school system shall be considered a specified group for purposes of the federal low-income housing tax credit program. How does the federal low-income housing tax credit program work?
So thank you, Delegate. The state determines criteria, and the state ultimately implements, the LIHTC program. So it really is up to the state to determine what criteria they use. You're asking specifically about who's included under these changes?
Yeah, so the tax credit program specifically, is it a limited amount of funding available, and does it go to the state? It's not, when I hear of tax credits, I always think of somebody filing their income tax return and getting a credit back on their return, but I'm assuming that's not how this works.
Yes, so I am not an expert in this, but I can tell you that we have projects that have gone through this process. Yes, there's a federal program, the states administer it, and when there are projects that come through, people apply through the state. And so it's not taking money away, or, I don't think it's just expanding the eligible use of the kind of projects that can come through.
So someone at the state level allocates the funding
DHCD.
to, so they'll allocate the funding to an applicant?
Yep.
So does this take money away potentially from another occupation if we're singling out this group, or how does that work?
I would say no, because it's very broad when they do the LIHTC. There are specific AMI, and the qualifications for AMI, average median income would still need to apply. You think about your learning specialist, support teachers. I have traveled around schools in Rockville and heard so many of them are traveling very, very long distances, not making a large salary. And they in particular are struggling to find housing nearby. So the AMI would still be a part of this. It's just expanding the pool of what kind of tenant could be in that housing.
And that median income, is that determined by county, or is it not county specific,
So LIHTC has, there is an AMI that's determined with the state and federal regulations. So we're not proposing to change that. That's right.
Okay. All right, thank you.
Thank you. Delegate Amprey.
Thank you, Madam Chair, and thank you, Delegate and Mayor, for coming out and having this bill. As a former educator, I did teach for America in DC and then taught in West Baltimore, and I actually lived in the zip code everywhere that I taught. And then my last years of teaching, I actually lived at the Seed School of Maryland, which is a public boarding school that we have here. So I believe wholeheartedly that living near your students is important, and I understand from my years teaching how much money you don't make. But the reality is, I guess I have several questions, but I guess the reality is that we actually do take really good care of our teachers here in Maryland in comparison to other states. Wish we could do more. We always wish we could do more. But the thing that, and I guess Delegate Weibel was kind of alluding to it, I'm concerned about how the median income would work with the group that you're trying to serve here under the LIHTC. Because I feel like our teachers would make more than the average citizen that would normally be eligible to live in these types of housing situations. And just trying to understand what that would look like. I know that I've offered bills in the past, and there's been bills in the past about how we can do a better job of helping teachers get on the pathway to home ownership, giving them, support on down payment, helping them get better access to lower interest rates. I think that's a great pathway. I think this is a good pathway maybe for newer teachers. But my concern is that we have a serious housing crisis, and I'm trying to understand if a teacher who's making, even I know 90,000 doesn't go as far as we'd like it to go in Montgomery County, but someone making 90,000, that's a good number if you look at Maryland as a whole. So I'm trying to understand how that would work here. If we're giving housing to that person making $90,000 versus the person making $35,000. Would they jump in line of that person? Just trying to understand the mechanics of how that will work here if we're going to do it that way. I just want to get a better understanding of how you all are thinking that through.
I can't speak necessarily to the mechanics, but I do want to call your attention to a report that the General Assembly requested last year of MSDE, which identified 13,000 education employees in Maryland who are earning less than $25 an hour. And you're not wrong to say that we take care of the teachers that we can keep. Because the high average salary that you mentioned isn't wrong, but that's a veteran educator. We're losing, as I said, half in their first 5 years. So maybe the delegate and the mayor can speak a little bit more about the actual mechanics of the bill, but I can definitely tell you, you've got educators in Maryland who will need affordable housing.
I was just going to add that I think what we've heard from some of the school system, and particularly this project that we've been talking about, the school system's ability to attract new educators is a factor. And so we are looking at that early professional who are trying to choose this profession in the first place, to choose our districts or our state in the first place. So I would just say early career teachers are a critical pathway. And as you heard, a lot of them are leaving within 5 years. So I think this is an important part of that. In addition, we must not forget that there are many paraeducators and other kinds of teachers that are meeting the social service needs and the disparities, whether that's through helping students with disabilities, helping students who are English language learners. There's a full spectrum of folks, and those folks are not getting that same salary that some of the full-time teachers are getting in that way. So I just wanted to specifically call out those, and those are some of the ones that I've actually helped on a number of issues where they are struggling to figure out their housing situation.
And Delegate, if I can just add, I think it's important to note that the tax credit portion of this around light tech is only one piece of this bill. There's other changes that we're making through this legislation that would still incentivize the construction of affordable development partnered educator workforce housing across the state. And we do have data, I don't have it in front of me right now, around how the AMI for light tech matches up with the average salaries for early career educators. I'll share that with you after the hearing.
Okay. Thank you. I think that, okay, Delegate Bhandari, and I just want to ask, if you can ask your question to one person, because I just want to remind folks that we have, we're like about a third of the way through our witnesses for the day, and so we have a long day ahead of us. So ask it to one person, and then one person answers, or whoever feels like they can do best.
Michael, I appreciate the intent of this bill. My question is about the implementation, because this bill allows county boards of education and municipal corporation to partner directly in a housing development using the available programs with DHCD type of program. Could you please clarify a little bit about the accountability measures? Does the bill rely on to ensure this project remain focused on educator workforce? Some of the teacher, a lot of teacher, when they do come with the different type of program, Teach for America, after certain years they leave, right? And we want to make sure that they do not drift toward general market rate housing once the initial financing and approval are secure. What does this bill envision about that?
Okay, since he didn't ask to one person, one of you can decide you want to answer it, and then we'll move on to the next bill.
Thank you, Delegate. I would say that first, I'd love to share with you the Rebuild Metro Baltimore program that already has educator housing in the state of Maryland and how they operate and how they make sure to address the concerns that you just raised. And in terms of accountability measures, I mean, that's definitely a concern, right? We don't want LEAs, school districts in the business of constructing just standard market rate housing. We want their housing to be focused on educators. I think this bill does a good job at narrowing the scope of what's allowed. But if I'm happy to work with you on language to strengthen that even further.
Thank
to
you.
address your concerns.
All right, thank you for that. That concludes this bill hearing, and yes, the fourth person is Joe Vogel again. So I think that's it. Thank you all so much for your testimony. And with that, we're going to move on to, Delegate Vogel again, this time for House Bill 80. And you can bring up your panel. Is that your panel? Same?
Thank you, Madam Chair. Yes, someone signed up for the city of Rockville, but we do have the mayor here who's testifying.
Okay.
It might have been Shaw, Councilmember Shaw, but.
We'll allow it.
Yeah,
Just go
all
ahead.
right, thank you.
Yep.
Madam Chair, committee members, here with House Bill 80. The House did pass this bill out of the House last year. It got stuck in the Senate, but we're hopeful that it'll get out of the Senate this year as well once it passes the House. This bill requires landlords, in particular those who own over 4 units, to clearly disclose all mandatory and optional fees to tenants. What we're really looking for here is, I'm a renter myself, and when I went to rent my apartment, the base rent was a certain amount, and then they added hundreds of dollars on top of that in additional fees. There's been stories here in the state where renters actually end up being surprised by the fees added onto their rent, not knowing clearly what they were signing up for, and then in their first month's rent, they owe hundreds of dollars on top of what they were expecting to pay in their rent. There's been a number of lawsuits on this issue across the state already. And so this legislation would require, as you're signing your lease, for the landlord to clearly display what all these fees are, what they add up to, and then require transparent all-in pricing. So if there's $200 of fees on top of your rent, the rent should show the total amount, including those fees. I actually think this would create greater fairness in the rental market, because for some smaller landlords that don't have 4 or more properties, right, they don't have the mechanisms by which to add all these fees every month, which then makes it seem like their properties are actually more expensive to rent, when in reality, that's not the case. So this not only creates transparency, but I believe it'll also give us greater fairness in the rental housing market. And with that, I urge a favorable report on House Bill 80.
Thank you. The mayor and council unanimously support HB 80. At a basic level, this increases transparency between landlords and tenants and a basic consumer protection and rights for tenants. It would require landlords to provide an itemized list that clearly identifies all fees the landlord may charge. Again, there has been practical experience in Rockville. We have also seen fees that are being added on or people didn't know about after. We think this is common sense, but too often tenants are frequently charged fees that are undisclosed, unpredictable, and arbitrary. The Urban Institute has found these junk fees can add 10 to 30% to a renter's total monthly cost, raising monthly payments above what households can afford. This transparency will help tenants to understand how much they will actually be charged upfront. Nearly half of all Rockville households are renters, and that continues to grow. Our community would really benefit from these additional protections. This also promotes fair and more competitive rental market when prospective renters receive the same clear upfront information. Anything you buy, you should know what the cost is. Anything you are entering a contract in, you should know what the total cost is. This also levels the playing field for responsible landlords who already operate transparently while discouraging practices that rely on surprise charges to drive up costs. Clear disclosure reduces confusion, disputes, and administrative burdens for both tenants and property owners. We urge a favorable report.
Thank you, Madam Chair. I was just wondering, and I may have missed it, I'm not sure. Did you give any examples of fees?
Yes, thank you, Delegate. Yeah,
So we've seen fees like after a tenant has already signed a lease, now you're going to pay for a package delivery fee. Like, you're just a basic ability to receive packages, some add-on fees to say, in order to accept packages in this building, we're going to start charging you a package fee. We've seen arbitrary double trash fees. So there are a range of fees like that that have just been popping up that tenants were not aware of before when they signed their lease.
Oh, okay, okay. So say for example, if a landlord, I mean, as long as it's in the lease, right? If it's provided in the lease, like a home warranty, the service call fee or something like that, because that's not gonna happen monthly, it's gonna happen when something breaks down or something like that. You're not talking about stuff like that, right?
No.
I mean, if it's in the lease, as long as it's in the lease.
Yeah, Delegate Roberts, I know you have a puppy, right? So like a pet fee, for example. We're not saying you can't charge a pet fee. We're saying if you're charging a pet fee, tell the renter what the cost of the pet fee is before they sign the lease, and then that pet fee needs to be included in the overall cost of the rent when it's presented to you, right? So it can't be, $1,200 plus then $50 on top. It needs to be $1,250. That's the cost of your rent.
Okay, all right, thanks.
Chair, welcome back. I guess as a realtor, we deal with fees and we deal with this all the time. I think it's an excellent idea that we try to do that. We try to tell people what they're going to pay and we break it down. I think it's an excellent idea, and I think people should be aware of all the fees that they're getting charged. Wouldn't you agree?
Yes, I agree. Thank you, Delegate. And I will note, it passed 135 to 4 out of the House last year.
Thank you.
Thank you, Madam Chair, and welcome back as well. Just a question on the action that you're allowing under the bill, 2 years after the tenancy expired and 3 times the amount of actual damages and reasonable attorney fees. How did you derive those terms?
Delegate, I think this is consistent with the bill that passed last year. Where exactly it's derived from, I have to get back to you.
I was just wondering how you came up with the 2-year limitation and the 3 times.
Yeah, I assume that it's consistent with other penalties, but I'll get back to you on the specifics,
All right,
on the specifics there.
This is directed to the sponsor. AOBA sent a favorable with amendment, and specifically that garbage collection be treated as a utility, and they stated that was in the bill that passed last session. So is this going to be in the bill that's we're going to use this session?
Delegate, that was amended into the bill last year. Ultimately, I defer to the judgment of the committee on this. I happen to think that is a pretty stable cost month to month. The argument that I heard for that in last year's hearing was that it could fluctuate like utilities do. Your gas bill might go up or down month by month. Your electric bill might go up and down. But trash pickup fees as a renter, they're pretty consistent. I think mine is $50 every month. So I don't really see a need to exempt that from having that. Because again, what we're doing here is just requiring that, A, that be clearly disclosed to renters, and B, that that be included in the overall cost of the rent. So I personally don't see an issue with including trash as a fee under this bill, but again, we'll defer to the judgment of the committee.
Okay, so you didn't present the bill the way it was amended last time?
That is, it was, the way that it was initially introduced, that amendment was made by the committee last year, but again, open.
You didn't add it this time?
We did not add the amendment, no. Yes, correct. Thank you, Madam Chair.
Good afternoon, Madam Chair. My name is Jennifer Mercer, and I'm a staff attorney at Pro Bono Resource Center of Maryland. I represent low-income tenants in Baltimore County and Baltimore City. Thank you to Delegate Vogel for sponsoring this important bill. Many times I've encountered clients who are taken by surprise when they are charged unexpected fees. For many of my clients, their landlords are claiming that they owe money even when they've paid base rent, and they don't understand why. This causes them significant distress and makes it functionally impossible for them to understand the balances on their rental ledgers. And once they do owe a balance, the fees tend to snowball from there, and my clients find themselves in a deeper and deeper hole. Often the fees do appear in the lease, but they are only disclosed many pages into the document, where I can say I have never seen a lease that does not disclose the base rent on the first page. House Bill 80 offers a simple solution to this problem by requiring landlords to disclose their fees prominently and upfront. It makes no restriction on what fees landlords may charge. It simply requires them to be transparent about that. Violations of this bill, should it become law, would be punishable by treble damages within 2 years, which does mirror existing Maryland law on the return of security deposits. Every first-year law student learns in their contract law class that a contract is supposed to represent a meeting of the minds, which means that all parties understand the rights and obligations they undertake when entering into a contract. A true meeting of the minds is impossible without both parties' complete understanding of the terms. Tenants are unable to assess whether or not they can truly afford a rental unit, and landlords often go without payment of money that they are owed under the contract. House Bill 80 helps both parties understand what the terms of the contract are so they can make an informed decision about whether or not to move forward. Pro Bono Resource Center of Maryland urges a favorable report. Thank you.
Good afternoon, Madam Chair, members of the committee. My name is Jennifer Bevan-Dangle. I'm the Deputy Director of Economic Action Maryland Fund. I came prepared to speak to our clients' experiences, which are very similar to what you just heard, so I will not reiterate. And in light of the strong support for this bill last year, I'll simply summarize by saying we do see this bill as good for both the tenants and the landlords. It's not in the landlord's interest to rent to a tenant who then finds out 2 months in that they actually cannot afford the rent. And now both parties are in an incredibly difficult situation. By ensuring transparency, by ensuring fairness across the board, this bill does make significant protections for both parties, and we urge, again, a favorable report.
Yes, thank you, Madam Chair. So what about in situations, I'm gonna go back to that example that I gave, say for example, the home warranty company. Well, we know something isn't gonna go wrong every month, but if there's a service fee for say $75 just for that, with a simple in the contract, what happens in that situation? Because that's not gonna spread out. You can't calculate what that's gonna be for an entire year. How would you approach that?
I'd have to consult with the sponsor and review the specific definitions if an intermittent fee like that is applicable. But it would seem to be fairly easy for landlord to say that you're under warranty, that if such and such happens, this would be the fee associated. And again, it's sort of in the best interest of both entities to know that, you know, this is a potential fee that you're facing should something break, should you need a replacement or a repair.
Okay, thanks.
Further questions for this panel? Seeing none, thank you very much. We'll move on to the favorable with amendments. That is Aaron Greenfield and Hugo Cantu.
Good afternoon, Madam Chair, members of the committee. Aaron Greenfield here on behalf of the Maryland Multi-Housing Association. We are favorable with amendments. You have our written testimony. Our members are certainly not opposed to disclosing mandatory fees. In fact, most of them do that anyways. We do offer the following 2 amendments, one which Delegate Queen raised that AOBA will echo concerning trash. We see trash as a utility. It is an essential, unavoidable cost and is very much a utility in our minds and how we practice our trade. And in fact, as Delegate Queen highlighted, this body passed the bill last year with trash collection deemed as a utility, so we would ask that the same thing occur. The second amendment concerns a language in the bill on page 3, lines 18 to 24. And in that provision, it allows local governments to supersede this statute, this bill. And the problem we have is many of our members operate in multiple jurisdictions at a time, and that becomes very unruly if you have different rules and laws in different jurisdictions in terms of how you advertise your rent. For those reasons, we respectfully request a favorable report with the amendments.
Good morning, good afternoon, Madam Chair and members of the committee. My name is Hugo Cantu, representing the Apartment and Office Building Association. For context, AOBA represents 133,000 apartment rental units between Montgomery and Prince George's counties. And our members are already disclosing fees to prospective tenants because of the Montgomery and Prince George's County rent stabilization law. And that's why we're here to support the sponsors bill. We appreciate what the sponsor's doing. We want to be open with our residents. And to the sponsor's point on trash fee, maybe in the sponsor's lease isn't fluctuating, that doesn't mean that none of them are fluctuating. I mean, there's thousands of apartment rental units, there's thousands of leases, and so we just want to make that point. And as a renter myself, something that changes often is how much trash is maybe left behind by a tenant that is moving on. My neighbor just last year left a large, like lots of their furniture just kind of left in the unit. Some feel it might be more expensive to haul it out and throw it away themselves, so they'll just leave it for the service or maintenance to pick it up and take it out. And so that's what we're talking about, the flexibility for our members. And our amendment can be found on page 2 of our written testimony, and we'll follow MMHA on their amendments. For those reasons, we urge a favorable report with amendments on HB 80.
Are there any questions for this panel? Seeing none, thank you very much. That concludes the bill hearing on House Bill 80. We'll now move on to House Bill 335. Delegate Rosenberg. And Delegate Rosenberg, we'll take up your next bill after this as well, so you can have a
Thank you, sure. Thank you, Madam Chair and members of the Economic Matters Committee. House Bill 335 would codify the holding of the Court of Special Appeals that when a road was a road that was initially a private road has been benefited from city or local government investment improvements that are necessary for it to be a passable road for traffic, public traffic, and in effect has been treated as a public road for 20 years, that constitutes effectively an easement, and therefore it should be considered a public road and no longer a private road. That was the court's holding in a recent case. I am here today because there is a neighborhood in the 41st District where this is an issue. And the city's position is that it will treat such roads as public roads, and therefore the beneficiary of public investment only in certain neighborhoods, that cannot afford the cost of maintaining the road. And that's not the holding of the court, nor would I suggest that it would be an appropriate action to provide services based on services that you are obligated to provide based on the wealth of the neighborhood. We are checking with the AG to make sure that the bill would be retroactive. And we have amendments that have been offered and should have been made available to the committee, I believe, that would strike State Highway Administration or the state government from the bill, thereby addressing the concern of SHA and also the basis of the any fiscal note that would put this at a significant cost. So that's what House Bill 335 would do and would seek basically, it puts in the code the holding of the Court of Special Appeals. It was a unanimous holding of a 3-judge panel on this topic, on this issue.
Thank you.
Appreciate your favorable action. Thank you.
Yes, thank you, Delegate Rosenberg. Delegate Adams?
If you had a court decision, what's the point of the bill? And I'm not on judiciary, so that's, I'm seeking information, not necessarily questioning the nature of it, but anyway.
Because the city is not following, to be blunt, because in this instance, in the neighborhood in my district, the city is not adhering to the court holding. And so we're proceeding. I'm a lot cheaper than a lawyer. And my colleagues. You get all 4 of us. The delegation is in support of this bill.
So a court decision is not being followed?
That's fair. That would be my view, yes.
Okay, and I'm unfamiliar with the example. So this isn't a two-party situation where one party wants it like the city and the other party doesn't want it. You're just simply saying that a decision was made and you're choosing to allow the legislature to compel a example, not, okay. I don't know that I have anything else to ask.
That would apply, obviously, citywide, well, not just citywide, but it would apply statewide. I mean, we've had discussions with MML, and they spoke on behalf of MACO to say that as the bill, as we have amended it, they do not oppose.
All right.
Delegate Arends?
I appreciate you bringing this. I have a situation in my county where we have, these are local roads that was a housing development over years ago that opted not to be part of county. Is that something that this bill would address, or this law case addressed?
My understanding of the law would be that if for 20 years a road has been treated as if it were a public road, that there has been public investment, something that comes to mind right now, snow plowing of the road by the jurisdiction, by the county, and not by the owner of the development or the residents, then the law
county has
treats
gone
it.
in there and done some of these things that you're speaking of over the years as being good people, take care of citizens. That's not what this thing was about. The court case.
Well, I think that the holding is about treating, if I could summarize it in English as opposed to legalese, is about if for 20 years if the responsible jurisdiction has treated this as if it were a public road, it is a public road.
Maybe I'll have them contact you because you're inexpensive. Thank you.
Limited jurisdiction, though.
Delegate Weigel?
Thank you, Madam Chair. I know in our county, we have a lot of roads that the county doesn't have a deeded right-of-way. How does this impact that? This would just automatically deed that to the county if it's been used that way for 20 years?
I believe so, that is, but that's one of 3 criteria, and I'm not an expert. I don't profess to be an expert on transportation
And MACO and MML haven't weighed in on this?
MML had concerns. We met with them, and they no longer have concerns. And MACO never corresponded with us, but I think it's fair to say that they have no concerns on the bill as it now stands.
Because the fiscal note says it has potential significant increase in local government expenditures. That an extent it requires local governments to maintain private roads to meet local government standards, increases liability exposure, and local highway user revenues may be affected. We don't have any answers to any of that.
I do know that State Highway Administration, by taking the state out of the bill, they no longer object. They're not here today.
Because you removed them.
Right.
All right, thanks.
Delegate Bhandari.
Thank you, Madam Chair. I really miss sitting next to you in the committee. And I know how carefully you ground legislation in existing law.
Thank you.
This bill seems to codify what Maryland courts have already recognized about long-maintained publicly used roads. Can you speak to how putting this standard into statute will give homeowners clarity and stability while preventing a sudden withdrawal of service they have relied on for decades? It's just the Baltimore City problem. It's a statewide problem. Could you clarify on that?
Well, the court, an opinion by the Court of Special Appeals applies to the entire state. So if other neighborhoods would benefit from this bill, they should, because that's the law. That is the law. A holding of the Court of Special Appeals can be changed by act of the legislature, but we're proposing that you uphold the decision by the Court of Special Appeals and recognize that 20 years of treating a piece of road as public, as if it were public, is sufficient to consider it public.
Thank you.
Thank you. Seeing no further questions, thank you very much, Delegate Rosenberg.
Thank
We
you.
do have one more favorable. It's a virtual. Jay
Yes.
Newman.
He was on the screen earlier.
You're muted, Mr. Newman.
How about that, Chairman? Can you hear me?
Yes, we hear you fine.
Great. I apologize. Good afternoon. Thank you for the opportunity to testify. I'm Jay Newman, president of the Poplar Hill Association, a Baltimore City neighborhood. Delegates, I ask you to just take a pause and picture in your own mind your home, your street. You've probably counted on city or county to maintain those roads for many years. Then imagine one day learning abruptly that your road has been reclassified as private and public maintenance services are suddenly withdrawn. How would you feel? This is exactly what happened in our community. For over 70 years, Baltimore City has maintained our roads. Then the city abruptly, several years ago, stopped those services, reclassifying our roads as private. A city official even telling our residents in a meeting, quote, "These roads are like my driveway. If you want them paved, go pave them yourself." Now, the city claims the roads are private, but Maryland court rulings, as Delegate Rosenberg has said, claim otherwise, that a public road is established by two criteria: through long uninterrupted public use for 20-plus years, and when a municipality has maintained the roads as public expense. Now, the city is going to tell you that they have a local law that allows them to work on private streets without making them public. They argue the local law supersedes state court ruling, but again, state courts disagree. Different municipalities handle this different ways, but many do adhere to the definition of public roads. Our request is pretty simple. Let's codify what the courts have already ruled so that all state residents are handled equally and fairly when it comes to their road. Roads open for public use for 20 years, having been maintained by city council and counties, should not be exempted by local codes. Thank you.
Thank you, Mr. Newman. I don't see any questions for you. Thank you very much for taking time in your schedule to be with us this afternoon. Seeing no further questions, that concludes the bill hearing on House Bill 335. We'll now move on to House Bill 343, also Delegate Rosenberg.
Thank you, Madam Chair and members of the Economic Matters Committee. Housing counselors are a recognized participant in our housing system. They give advice to people who have recently bought properties to make sure that they, or to do their best to make sure that they keep their properties and not lose them through the court system or whatever the case may be. In working on this bill, I became aware of that perhaps we should focus where the appropriation is and thus narrow which also highlight the problem as well as reduce the cost. And so what the amendment that I've offered would provide that the $100,000 that the bill would put into the budget for a year from now, not the fiscal year budget that's before us, but a year from now, would provide $100,000 for the Baltimore Vacant Reinvestment Initiative, which is something that is being funded by both the city and the state. I am certainly open, if the committee wants to move forward with the bill, and I hope you do, if you broaden the scope of, this shouldn't be a Baltimore-only bill. There's a real need because you've got a significant vacant housing problem in the city, but that's a need that is not limited to the city, and I recognize that the committee may want to broaden the scope of the bill, but I think the key point would be provide this assistance to people who are investing in what were once vacant properties. The reason for that being, these are the people who most likely have not been homeowners before if their investment is in a formerly vacant property. So they are more in need of the expertise and the advice of the housing counselors. There will be witnesses who can speak more specifically to the housing counselors, people that I've worked with in my district, who are the people who brought this idea to me, that housing counselors would be of significant benefit to homeowners who are not don't have the experience as homeowners and therefore are at greater risk of losing their home. And the counselors would reduce that risk, address that problem. So I would look forward to working with the committee or ever to move this issue forward. Thank you very much.
Thank you. Are there any questions for the delegate? Seeing none, thank you very much, Delegate Rosenberg.
Thank you.
Now, yes. Now call on Marida Goodman. Yes.
Okay. Good afternoon. My name is Marita Goodman, and I am the Executive Director at Go Northwest Housing Resource Center in Baltimore, Maryland, where we provide housing counseling and financial education and technical assistance and resources to individuals, predominantly low to moderate, but individuals to be able to stabilize, build, and strengthen financial capacity and secure, maintain a home, and avoid foreclosure. And we are strongly supportive of this bill. Housing counseling is not a peripheral type of service. It is a vital support that protects public investment in housing development and helps make homeownership a reality for many households in Baltimore, but throughout Maryland. This bill strengthens housing outcomes by pairing capital investment with resident readiness, reducing displacement risks that can result from housing development projects, improving long-term occupancy, and ensuring that the redevelopment benefits not existing communities as well as future residents. We find that building or rehabbing without this intentional readiness services risk creating empty units and displacing families. We feel that successful revitalization would include both supply expansion and capacity building. Requiring housing counseling would serve as a prevention that reduces downstream public costs. Housing counseling lowers the rate of foreclosure, eviction, and housing instability. It also provides a positive return on the state's investment. With the state investing millions of dollars in housing development, we find that this bill will help achieve that goal by securing access and funding for that part of the process that works to bring equipped buyers to the table. So we just urge you to support this bill. Thank you.
Thank you, Ms. Goodman. Are there any questions? Seeing none, thank you very much for presenting your testimony. We have two virtual testimony for favorable, Katina Thompson and then Sean Diggs. Go ahead, Mr. Diggs.
Okay, sorry. Can you all hear me?
Yes.
Good afternoon. How you doing? Thanks to the committee and everyone. My name is Sean Diggs. I'm 46 years old. I was in the program back in July, I believe, or maybe a little earlier than that. I am 46 years old. I have 3 children and 1 grandson. I currently live in Baltimore County, the Rosedale area and community, and let me just say that I love it. I love the area I live in, and the community has been great. My current profession is I'm a certified peer recovery specialist, a state care coordinator for Baltimore City, certification as an alcohol and drug trainee. I myself am a person in long-term recovery, that being 16 years. I've been working in a public health capacity for over 16 years. Currently, I work as a state care coordinator for a nonprofit organization in Maryland, which helps to fund those that are seeking treatment and rehabilitation for mental health and substance use disorders to gain transitional housing. So I do know how much housing matters, especially to those that have done the necessary work to build, rehabilitate, even rebuild in order to overcome the various challenges within our society. I have worked with the homeless community along my professional journey, and I have also been homeless myself for a short time. Once I encountered Ms. Lee in the First Time Home Buyers Counseling Program, it was very enlightening, educational, and just really helped me begin on the path to know that I had some backing and some support and giving me that belief that I could become a homeowner. Just that confidence, it was awesome. They helped me immensely and made the process go smoothly. Let me just say that I've never owned my own place. I never had an apartment or anything like that. And for a while, I didn't think that this dream could come true for me, owning my own home. Yes, this truly is a dream come true. And I often fall to my knees just thanking God that I have, a place for my children and my grandson to come. There's no other feeling like that, especially where I come from. I really would like to see others obtain their dreams and becoming a homeowner, and I have made it my duty going forward to inspire, enlighten, and educate people in believing and seeing that they too can do this. Just to be able to give my testimony here on this platform, I was honored and jumped at the opportunity and to speak highly of this counseling program, the First Time Home Buyers, hoping that we can make an impact with this bill being passed. And I'm just thankful, and thanks for the opportunity.
Thank you, Mr. Diggs. Seeing no questions, thank you for participating. Our next person to testify is Katina Thompson. Okay, moving on. We have favorable with amendments now. We have Claudia Wilson Randall.
Good afternoon, Chair, members of the Economic Matters Committee. My name is Claudia Wilson Randall. I'm the Executive Director of the Community Development Network of Maryland. We're a statewide network of housing and community development partners across the state, of which Marita Goodwin, who just testified previously, is one of our members, and we have many organizations throughout the state like Garwin Oaks, Go Northwest, and so I'm happy to be here in support of House Bill 343 with amendments. You have my written testimony. As has been previously spoken, housing counseling is a vital resource and service, and it's essential that we provide support for this service. I think it's not enough for us, state, to invest in development. We also have to make sure that we're investing in the people who help people actually become owner occupants of homes. So I really just applaud the work that this group does. The Community Development Network has a housing counseling part of our work, and these are strong and important organizations. My amendments to this bill ask that we just narrow the bill to DHCD's Strategic Demolition and Baltimore Vacant Reinvestment Initiative, specifically to where we are looking to get single-family home ownership. So I just put in those amendments. I thank you so much for the sponsor in accepting those amendments. I'm happy to answer any questions, but I think this is really important work that is being done. It is often the unglamorous work of housing development. It is not the ribbon cutting or the bricks and sticks, but really getting a homeowner in place and working with them on credit and budgeting and all of the details. Thank you so much for your time, and again, my support, strong support for House Bill 343 with the amendments that I provided.
Thank you, Ms. Randall. Seeing no questions, thank you very much. Our last witness is a virtual, favorable with amendment, Meredith McAllister. I'm actually here. Oh, you're here. Okay, come. Please come forward. We have you listed as virtual, so maybe signing up.
Thank you. My name's Meredith McAllister. Thank you, committee and chair, for hearing my testimony. I come to you as a recent home buyer. I am a housing counselor, don't get me wrong, but I am also a recent home buyer, and I think it was important for me to come and bring about the information that I provided in my written testimony, but also to talk to you about a couple specific things that you may need to hear. One of the things is when we're, as housing counseling, looking for funding, and we know that there has been a political climate that has made it difficult to expand funding. It's actually shrinking. When we're going to our philanthropic, our financial partners, often they're saying, hey, why don't we see more investment in what you do to a beneficiary who takes immediate benefit from it, which are the developers. So one of the things that I support about this bill is that it does bring another stakeholder who is also benefiting from the services we provide in providing a pool of mortgage-ready home buyers, but also potentially renters who have experience who will not fall into some of the issues we heard on some of the bills that talked about things that renters need to know in order to be successful. Lowering foreclosure and eviction helps us with your downstream costs with regards to government in terms of legal services, providers, and also loss of tax base and all of the negativity that is associated financially. But of course, it also helps us with lowering the potential for blight and also improving our blighted situations by making sure that, as my boss often says, it's not a case where if you build it, they will come. We have to invest intentionally early in the process. And so my amendments were that the counseling be considered before the buyer goes under contract or before the lessee signs a lease, and also that there be some incentive to the developer through the point system that DHCD uses to score applications if they include this type of partnership in the development proposal.
Thank you, Ms. McAllister, for your testimony. I'm looking around. I see no questions for you. Thank you very much. This officially concludes the bill hearing on House Bill 343. We'll now move on to House Bill 313. Delegate Stewart.
Can I bring a panel up?
Yes, please.
Thank you, Madam Chair. All right, I'll go ahead and get started. Madam Chair, Madam Vice Chair, members of the Economic Matters Committee, thanks so much for the opportunity to testify. This is House Bill 313, and my name is Vaughn Stewart. So imagine a scenario where a tenant is living with, let's say, 3 children in an uninhabitable apartment. And let's say there's mold, there's rats, the heat doesn't work. Like, imagine whatever scenario you want. That tenant legally withholds their money under Maryland law and goes to court over it. Let's say that maybe it's an escrow, maybe the landlord files a failure to pay rent action against them, and the tenant wins the lawsuit because actually no rent was owed because the tenant was living in a place that was utterly terrifying and uninhabitable. Well, unfortunately, what then happens, and oftentimes it's, let's say, finally, whether she gets rental assistance or she collects enough money to find another place, months later, she's surprised to learn that she is denied living in another apartment. And it may take her months to figure out why. She may ask the next landlord that she's applied to, why was I denied? She may not know. She may eventually, after a long period of trying, months later, weeks later, find a copy of her tenant screening report. A tenant screening report is used by landlords, and we're going to hear about these kinds of things for the next couple of bills. A landlord uses tenant screening reports to find out the history of a tenant, their rental history, did they pay on time, have there been evictions before? And so this particular mom of 3, she finds that her tenant screening report in big fat red letters says eviction next to her prior place of residence. And she's startled by this. This has to be an error because she was never evicted. There was an eviction action filed, an errant one that she won. She won the case, and now she's denied from place after place after place and is driven into homelessness because she has this now black mark, or red mark in this case, on her tenant screening report that is now going to follow her around for years to come. She did everything right, but she can't find housing. And so HB 313 is about transparency, accuracy, and fairness in a tenant screening system that is increasingly high stakes, automated, and error prone. So tenant screening is driven by third-party aggregators. Basically, these tenant screening companies pop up and they scrape data, oftentimes public data, from courthouses. And then they use AI to translate the data they've scraped into something that's readable and understandable by the landlord. But mistakes can be made on both ends. So first, they may be scraping data that itself is obsolete or expunged. In our case, because we did pass an expungement law, a shielding law a few years ago, they can scrape data that's old, obsolete, expunged, which is bad. And they can also take data that's technically correct, but misinterpret it through their own tools and label something that, for example, shows that the tenant won a landlord-tenant proceeding, but somehow that ends up on the tenant screening report saying eviction. These are things that I've seen personally and met tenants who have personally experienced these kinds of problems over and over and over. So what does the bill do? HB 313, 1, landlords should provide upfront disclosure about their screening criteria because tenants should not pay an application fee only to be left holding the bag when they realize what the screening criteria is and how they would have never been eligible to live in the unit in the first place. Second, landlords should provide why they were denied. Federal law actually already requires this, but a lot of times we see landlords are not complying with the FCRA on the point of providing what's called an adverse action letter, where you tell the tenant why you decline them. Importantly, landlords should also, under the bill, be required to attach the tenant screening report itself. Because even if the landlord says, okay, this is why you got denied, if that tenant is not able to see the physical tenant screening report that shows that eviction in red letters, she's never going to figure out the problem. She's never going to figure out why she's really being denied unless she sees the report itself. The landlord's got it right there. They've got the PDF saved on their laptop. This bill just requires it to attach it to the adverse action email. Simple as that, so that the tenant doesn't have to go to this third-party company and email them and call them and send them snail mail letters to try to get a copy of that screening report, which unfortunately happens too often. And then third, what the bill does, and probably most controversially, but also most potently, it says that if information, non-judgment, so not like a real judgment or not like an actual eviction, but if a non-judgment information, this was like a Delegate Terry Hill bill a few years ago, if you guys remember, we said that if you've got old information on there and a tenant actually won, if something was filed against a tenant won, it shouldn't just languish on Maryland Judiciary Case Search forever. It should be expunged past a certain date. Well, here's the problem with that bill. All of these tenant screening company aggregators, they're able to scrape it before it's expunged. So even though it's not on the Maryland Judiciary Case Search anymore because of Delegate Hill's heroics and our heroics in the General Assembly, well, all of these companies still have the data. They've scraped it all. So they can and still do use the shielded expunged data. Then they use that data to make errors with, even though we passed that law. So this bill is pretty straightforward. This process can be a lot fairer and a lot more transparent. I'm fully for tenant screening. The opponents will, will tell you that like this prevents tenants from seeing people who are chronically late on their bills or bad tenants or whatever. That's not true. I want tenants to be screened. Landlords should have that information, but it should be based on real, transparent data that actually happen, not misinterpretations caused by automation. And tenants should be able to see their reports and the reasons for their denial so that then they can go challenge those errors themselves and find housing. Happy to take any questions. Really appreciate y'all's time and urge your favorable report.
Madam Chair, Vice Chair, and members of the committee, thank you for the opportunity to testify. My name is Adria Crutchfield, Executive Director of the Baltimore Regional Housing Partnership, here today in strong support of HB 313. BRHP administers the Baltimore Housing Mobility Program, supporting more than 4,300 low-income families with housing choice vouchers and housing mobility counseling across the Baltimore region. We consistently hear from participants frustrated by lengthy housing searches requiring multiple applications and denials based on screening requirements they weren't aware of prior to applying. These denials prolong housing searches. Additionally, they add a lot of costly application fees, and they prevent families from accessing homes in high opportunity neighborhoods. HB 313 introduces essential transparency and fairness into this process. It ensures that before any fee is collected, applicants know what the screening criteria are, what information will be used, and whether a unit is actually available. And when a denial occurs, the bill requires landlords to provide specific reasons, the screening report they relied on, and clear instructions on how applicants can dispute inaccurate information. This is an important consumer fairness issue because the Consumer Financial Protection Bureau has documented widespread inaccuracies across the tenant screening industry, ranging from outdated reports to information belonging to the wrong person, and has noted the difficulty prospective tenants have correcting these errors. The bill also ensures renters are only evaluated based on lawful and relevant criteria by prohibiting the use of shielded and sealed eviction records. HB 313 benefits both renters and housing providers. When expectations are clear, application decisions are based on accurate information, and disputes are reduced. This leads to faster lease-ups, fewer vacancies, and a more transparent system for everyone involved. For these reasons, BRHP urges a favorable report on HB 313. Thank you for your commitment to fair housing access in Maryland.
Hey, good afternoon again. Madam Chair, members of the committee, Zephyr Shaw, Maryland Legal Aid. Our perspective on this bill is colored by our practice at Legal Aid, where we don't help tenants find housing opportunities unless they're racing against the clock. For instance, to move a voucher, typically with only 60 days to do so from the Housing Authority, or they're trying to avoid an eviction after judgment, and they're literally racing against the time it takes for the warrant to be scheduled for the eviction. They apply and apply. I mean, this is the story I hear from clients over and over again, of applying and applying, paying application fee after application fee, and being summarily denied, and they don't know why. And they don't know about the Fair Credit Reporting Act. And even if they did, the Fair Credit Reporting Act provides a property owner to share information about the denial within a reasonable time after the denial. Well, my clients don't have a reasonable time. They're, again, racing against the clock. And what this bill does so importantly, and why we urge a favorable report on House Bill 313, is that it creates a timeline, a real deadline, where the provider denying housing must provide that disclosure of the information and the specifics about the reason for denial when they make that decision, and they actually call or they email or whatever they're going to do, contact our client. They have to provide that copy of the screening report. I want to make one other point about my client, our client, who I detailed in our written testimony, is that he had a good credit score. He had employment. He didn't know why he was denied housing. Well, we helped him get that adverse action letter through advocacy, and the reason was just a misunderstanding. He didn't have a chance under current law to dispute the denial. This bill provides that right to dispute, and there are enforcement mechanisms. I'll conclude there and urge a favorable report.
Thank you, Madam Chair, Madam Vice Chair, members of the committee. Again, my name is Matt Hill. I'm an attorney with the Public Justice Center. We also urge a favorable report. I won't repeat what my colleagues have said, but just to give you one more example, we also have clients who are just desperate to find housing. And for one client I have right now, she's a mom, she's disabled, she has a mobility issue. She has 2 teenage boys. She really wants to start a home daycare, and she's gone through the process to get licensed by the state. Now she's trying to find a rental unit in which she can open her home daycare. She can't find anyone. She can't find anyone not because she wants to open home daycare, but because she's being rejected repeatedly. She's paying hundreds of dollars in fees and at least 15 properties, and she's not told what the screening criteria are. And then she comes to me and says, Matt, I don't know why they're rejecting me. Now, we're going to try to help her figure it out. We're going to get that report. We're going to drill down a little bit. But she shouldn't have to get an attorney to figure out what the screening criteria are, not pay the application fee if she's not going to meet it, and then have some reason told to her in writing as to why she's being rejected. This is very simple, and if you all have ever applied for credit for a loan, you have the same rights. We want to extend those rights to my client and the hundreds of other families who are desperate to find affordable housing and not create this sort of hide-the-ball scavenger hunt for housing where no one knows what the rules are and no one even knows why they can't find what they're supposed to find. Thank you.
Good afternoon, Madam Chair, members of the committee. My name is Jennifer Bevan Dangle. I'm the Deputy Director of Economic Action Maryland Fund. We are also here in support of House Bill 313. Our tenant advocacy program speaks with clients. You've heard the stories. You have them in your written testimony. But this is a very common issue for people who are in desperate times, people who, as you've heard, are spending hundreds of dollars and countless hours trying to find housing that they can afford for themselves and their families. This is also a critical consumer protection issue. As we've seen funding for the Consumer Financial Protection Bureau gutted at the federal level, there is really nowhere for individuals to turn at the federal level to deal with these programs and these systems that are pulling these fraudulent reports. So it really is on Maryland to act and to fill that gap to make sure that our tenants, that our renters have the ability to correct these inaccurate reports. These reports are circumventing Maryland law. This legislature has spent countless hours debating what should be shielded, what should be sealed. And the fact that these generated reports can scrape that data, can go around the law that this legislature has debated and passed, and still put these things on someone's record and have them denied housing because of it, this is an important area to clean up, to make sure that the Maryland laws are what they are and that things that are supposed to be shielded actually are. So for all those reasons, we join in urging a favorable report.
Thank you. Delegate Pippy.
Thank you, Madam Chair. Delegate, good to see you. Couple questions. One is for clarification. So what is the impetus behind the not advertising a place for rent if it's not going to be available for 30 days?
I'm actually really glad you brought this up because I didn't fit it into my remarks, and I know this is something in the opposition that they harp on. So one of the provisions in the bill that I did not get to is that basically we don't want landlords to do what a small minority sometimes do. We've seen this all the time. They will advertise a unit for availability that's not actually available. It's not actually online for a number of different reasons. Maybe someone is staying past when they were supposed to move out, or a number of different reasons. But landlords will offer it. They will receive a bounty of application fees, and they will deny everyone's application because the unit is actually not available. So they've now taken hundreds of dollars in application fees from people who wanted a place to live when there was actually no place to live. That's what we were trying to get at. Now, I think there are some technical problems with the way the original draft is. I'm happy to work with all my friends in the housing provider community, as I always do, to work out some kinks here. I think a few of them raised some issues about whether it should be like 60 days instead of 30 days. There's some minutia there. I'm more than happy to work with them to make sure that provision works well. I totally understand that sometimes you need like a longer time horizon to be able to figure out when is something going to come online and when it's going to be available. I don't think that that's like a deal breaker for the bill at all. I'm happy to work with them on that.
So I will say that's interesting. And I feel that could be something that might be reasonable. The only concern I would have is if a landlord thought the property would be available, but let's say the local municipality refused to issue some sort of permit or something, and then that technically made it unavailable, would this landlord then be I mean, you got some teeth in this bill. You know, you said 500 per violation, but if it's also a violation of the Consumer Protection Act, I mean, that's a lot of money, like $10,000, $20,000 per, I mean, that's some serious teeth.
I'm happy. Yeah, we love teeth over here, Delegate Pippi. But I am happy to work with you. Sorry, I didn't mean to cut you off. I'm happy to work with you on that provision. You're right. I don't want good faith landlords to be caught up in the teeth of this bill because of a third party who made a unit available that they thought would be available. If there's some sort of like bad faith or specific intent language,
like knowingly or something.
Exactly.
Because there's a big difference, and I'm with you on if somebody knowingly took rental applications for a place that was never going to be available. I'm sure that should
with reckless disregard or whatever.
So that's one thing. That's part one.
I think we can fix that.
So part two that I have some concerns with is the shielding part. So for example, at least in the old days, you know, references were important for rentals. You know, I'm having reference, maybe even a reference from a previous landlord. So if you have a scenario in which, let's say, you rented from a previous landlord and then there was some sort of legal action taken, like something filed, and then it was like dismissed or withdrawn or negotiated. A lot of these things, they're like cash for keys, you know, the industry. I mean, you know, there's no adjudication per se. It's just, I don't know. You get it. There's a lot of different ways to withdraw.
Stay and pay regimes.
So the case gets maybe shielded of some sort, and now the landlord is not allowed to even inquire. I mean, based on what is written here, not even allowed to inquire about what occurred. Like there's no, I'm just wondering, is there now a prohibition completely of even having a discussion about this person's rental history at all? Because if the tenant had, let's say, 2 previous leases, both those cases were shielded, he's not allowed to ask for any reference, and if he does, it's a violation of the Consumer Protection Act, you know, and then you're subject to a whole lot of problems. So if you could help me work through that part.
Yeah, and I think these are good points. The intent here is not to bar any sort of reference scheme or any sort of inquiry whatsoever into a tenant's past record. The intent is that we made a decision. I know that a few people in this room voted against it, but we did make a policy decision that old court filings where the tenant prevailed or no one prevailed and it was dismissed for some reason should be taken off of Maryland Judiciary Case Search. My only point is that if we've made that policy decision that it shouldn't even be on the website anymore, we shouldn't allow data aggregators to hold on to that old expunged data because they scraped it before it was expunged. Now, to your point about references and inquiring and calling, that's not in the bill. And if you want to put the language together that makes it more clear, I'm happy to work with you and our friends behind me.
And I'm going to use your example, and then I'm done, more succinctly. So if there was a record of some sort that was shielded or taken off MDEC, case search, whatever, would this bill, as written, prohibit or subject the landlord from calling the previous landlord?
No.
Are you sure? I mean, couldn't someone make the argument that, hey, this is all covered under that shielding, you can't ask any questions?
I am sure, Delegate, but if some other attorney in the room disagrees with my reading of the current draft of the bill, I'm happy to make it even more crystal clear.
Because it says, may not disclose information about a proceeding or shielded record, and so I'm just wondering if any information would be under the, okay. You get where I'm going.
I do, and I think that's an extremely good point, and I think we can fix it. If there's something to be fixed in the current draft, I think that's something that the committee should fix, and I'm happy to put an amendment into the committee.
Thank you.
Delegate Adams and then Ahrens.
Thank you, Chair. And to the sponsor, I'm just going to pile on. The provision that this falls in violation of the Consumer Protection Act. I mean, you and I have been back and forth. I'm going to do this without editorial and to say that I think you know where I stand on that, and I think Delegate Pippy took care of the bulk of what I would want to say there. When there is an eviction, all right, so a case has been brought, a judgment's been made, and before the date where the tenant actually gets removed from the property through the lens of law enforcement shows up and clears the property. I don't know what the legal term for this is, but in layman's terms, is that there's the day where the eviction happens.
Yeah, eviction. Yeah,
but the tenant leaves before that.
Right.
All right, so I'm not 100% sure how that is.
So no eviction has occurred, but a warrant has been issued and a judgment has been made.
Okay, but the point is, if a person leaves or vacates the unit before the day that law enforcement comes up, what I have heard, okay, and your constituents have told you your piece, but there are these examples of when people leave before that they weren't in fact evicted. Now, I don't know if that's a legal determination. In fact, it probably isn't. Once you get the judgment and you leave because you didn't pay the rent or you did something that violated key provisions of the lease. And I guess what I'm trying to get at is, would your bill in effect say that no eviction occurred, although the tenant was going to be evicted but left notwithstanding?
Fantastic question. My position and what the bill's position is that if there is a judgment in favor of the landlord, that should absolutely be on someone's tenant screening report, whether or not someone has departed before the eviction was finalized. I would actually say in a situation where someone has moved out that there was a judgment, but there was not an eviction because the sheriff never came, the person was actually never evicted. They kind of self-evicted, right? But there was no eviction. But the bill's position is that eviction is not really the relevant determination. The relevant determination is that there's a judgment. And if there was a judgment, I think that should absolutely be something that landlords should consider in screening prospective tenants.
All right,
but if there was not a judgment, then no.
All right, so the follow-up to that is, in that same eviction setting where the landlord is at the unit, at the property, there's law enforcement, and the tenant comes up with the $1,500 in the form of money order or cash or whatever, and therefore is not removed from the property.
Right.
Your position remains that the eviction judgment or whatever that looks like stays, notwithstanding the action that the tenant took to resolve the issue.
My position is that's called staying in pain under Maryland law, which is very legal and very legal up until the time literally that you're forced out. You can just pay with the rent that's owed and stay, a very important tenant right. But my position is in that scenario, almost always, unless it's some sort of self-help eviction, there has been a judgment, and therefore, again, that judgment would be still on the tenant screening report pursuant to the language in the bill, even if they stayed and paid.
Then I've got to ask the last question, because if the legislative intent is to not cover one of those two scenarios, what exactly are you trying to protect under the?
Yeah, I'm trying to protect situations where there has not been a judgment, where there has been a failure to pay rent action filed or some kind of eviction action has been filed, but it did not result in a judgment. That's the direction that we went in with the Delegate Hill bill, so we're kind of following her lead on this. So my position is just if you've got information that has already been shielded or expunged or screened or however you want to call it under that previous bill, basically a filing that did not result in a judgment, either because the tenant was right or it was dismissed for some other reason or the landlord withdrew or whatever, I don't think that's fair to hold against a tenant.
All right, so to save time, let me just then ask the final question. So in the setting where a filing has been made for like non-payment of rent, okay, so the court date's a week or 2 weeks or whatever that looks like. We had that bill before today. And that before the judgment, before the date of the court hearing, the tenant comes in and pays the rent. Your concern is that you think that the courts might still file a judgment against the tenant?
No. My position is this. Tenant screening reports have information.
Can I stop you there?
Yeah.
This means I need to just sit down offline.
Yeah, we'll chat about it.
Because I'm concerned that there are plenty of examples of where what's going to happen here is that there are going to be plenty of examples of how somebody avoids the actual eviction, and that somehow or another becomes part of the obligation of the landlord to all of a sudden have to defend themselves or to protect their interests in the case of, I'll go back to Delegate Pippy's concern, which is this is a violation of the Consumer Protection Act, which is as heavy a violation that this committee can possibly handle. And I just, the burden doesn't match what I'm thinking your bill's trying to do, and I'm missing it, so we'll do it offline.
Okay, sounds good. I appreciate you.
Delegate Aaron's, and then Roberts.
Thank you. Delegate, it's good to see you again. Just for the record, I want to know, you're right. I want to tell you, you're right on this. If somebody's advertising a place for rent and they're getting that should be addressed. But when I look at this thing, I'm looking at the realtor side of it. And you're saying in this bill that if I have a place, let's say within 30 days, I have to, a rental, I got a rental coming out in 3 months. I know my tenant's leaving me and I got a rental 3 months down the road, that I have to wait for 30 days to actually check on the prospective tenant. Is that right? So 30 days prior to, within 30 days of the rental becoming vacant.
I think that's what it says. Okay. Yeah, and I have to go back and read the realtor's written opposition. But let me just cut to the chase here, which is that I also like the realtors, and I love Mr. Castelli. I think he's probably behind me. Yeah, he is. I can see him actually through the screen. Hey, Bill. Let me just say, Bill and I have worked these issues out before. I have full confidence that on that issue in particular, the availability thing, I'm more than happy to sit down with them, and I think we can come up with a compromise. So I wouldn't worry about that one.
Well, I worry about it because if that time frame means something to somebody, like when I sell a property, if I have somebody that's trying to move into another property, or selling their home, they need a home in 90 days.
Yeah.
They don't need it in 30 days. And my property's coming up for rent in 90 days. This bill will stop me from running their credit check and doing all the things I need to do on them at that 90-day point, so they can actually feel comfortable about closing on their home and have another place to live till they find another home. Is that right?
So I think the issue that they've raised is basically like what the word availability means in the bill, right? And that is their reading, that's not my intent. My intent, and if we have to make an amendment to basically expressly clarify that like this is just units with a known scheduled availability date, and if we even need to bump the number up or down however they want, this is not a hill I'm going to die on. I think we can all come up with a reasonable.
I want, for the record, I don't want you to die.
Well, I really appreciate that, Delegate Aaron's. That's a relief.
Okay, I think it does need some work here because there's a lot of problems with this for somebody in my business. I don't see it workable, but thank you very much.
Okay, appreciate you.
Delegate Roberts.
Thank you, Madam Chair, and thank you, Delegate, for bringing the bill. I just, I guess I had some concerns, and I think you may have already answered the question, because my concern was basically if this bill is going to unintentionally harm smaller landlords who may like own 1 or 2 or 3 properties or something like that, and, you know, they need a little more flexibility with the timeline. But I also wonder if it's going to open doors to more litigation from rejected applications, which can also be harmful to smaller landlords.
So I would say that generally small landlords very often don't rely on these fancy tenant screening reports. A lot of times they actually will do what Delegate Pippi talked about and kind of use word of mouth and references and more informal practices to vet tenants rather than, you know, buying some sort of big tenant screening report. So I think in that way, they're not exempted from the bill, but it is a little bit less applicable to small landlords than maybe some other bills that you guys are going to hear. I actually do think this is an anti-litigation bill, however, for small and big landlords alike, because I think if you provide clear expectations to tenants about what the screening criteria is, if you present them with the reason for their denial and they have the screening report right there in front of them, there's an opportunity to dispute if there's any incorrect information and work this out in a way that avoids litigation. I think you get people that are litigation happy as someone who litigates. You get people who are litigation happy when they feel like they got the rug pulled out from under them, when they were not told up front what the expectations were, when they aren't given all the information and the tools they need to understand a decision's being made. That's when you get angry people who sue, and even if they're not meritorious lawsuits, it drives up litigation costs for landlords. And so I think this bill actually will reduce the number of lawsuits. Now, to Delegate Pippi and Delegate Adams' point, maybe we need to look at what some of the enforcement and remedies are to get this through the committee. I'm always willing to talk and have those conversations. But in terms of whether we're going to have more or less lawsuits, I think we're going to have less from this bill.
Okay, and then the other thing that I was just wondering about is, and I think that Delegate Chris.
One of those guys, yeah.
But I think he brought it up, but when people move out, avoiding the eviction process, that happens a lot.
Totally. Oh, it does, yeah.
And I just wonder if there's way to address that in, like, for a landlord? That means that that won't show up on their screening
If there's a
report,
judgment,
right?
it will. If there's a judgment, it
But
will.
if there's not,
Right.
they just got away scot-free, and then they can go and do that to somebody else. So I was just wondering if, if
Right. I mean, the issue is without a court rendering a decision about who wins and who loses,
That's the only
we don't
way.
really know, right? And so
Okay.
to me, unfortunately, what we're seeing is that these tenant screening companies, sometimes they're fly-by-night operations. You know, the credit reporting companies, not to go on a big tangent, but Experian, Equifax, and TransUnion, they're decades-old companies that have they still make mistakes, but they're decades-old companies that have a massive number of employees designed to ensure accurate reports. These tenant screening companies, there are hundreds of these, including some that are like just founded by like 22-year-old like college guys who just like live in their parents' basement in Texas. Like there are hundreds of these tenant screening companies. They're all using AI and they're all using scraping tools, and they're much less regulated, and they're using automation. And in a lot of cases, we don't even have websites. We can't even track them down to get the tenant screening reports. I just don't trust those people to necessarily take what is necessarily gray information of who was right and who was wrong in a landlord-tenant dispute when we don't have a judgment. If we have a judgment, whether someone's actually been evicted or moved out or whatever, then sure, that is absolutely something the landlord should know about. But until we have that, I think we're going to have too many cases where we're going to have bad data and we're going to have people homeless because people made mistakes.
Okay, thank you.
Thank you.
Thank you. Thank you.
Seeing no further questions for this panel, thank you very much, Delegate Stewart.
Thank you, Madam Chair.
We'll now move to the opposition. Michael Cerrito, Matthew Pipkin, Bill Castelli, and Ryan Anlou.
All right. Good afternoon, Madam Chair, Madam Vice Chairs, members of the committee. Brian Anlou with the Apartment and Office Building Association of Metro Washington. I just want to start off by saying that AOBA agrees with the screening disclosure criteria. We're not trying to hide what screening criteria is used or anything like that. And to the best of my knowledge, AOBA members in Montgomery and Prince George's County already provide that to tenants. And to the extent that they don't, I think that they should. We also agree with not using shielded records, obviously. However, we're concerned that this bill over-regulates the leasing process, specifically the restriction from leasing a unit 30 days before it becomes available. We think that that will impact the lease-up process for new development. You heard last week what some of the challenges that we're having with attracting new development to Maryland, and particularly the largest counties in Maryland, and that would certainly have an impact because lease-up is important to getting the building stabilized and occupied. Some buildings with a lot of units, 400 units or more, take a really long time to lease, and if you can't lease them until 30 days before they become available, that is a challenge. I also want to make clear that landlords aren't making money from application fees. In Montgomery and Prince George's County, the application fees are $25. And to the extent that they're more than that, it's tied to the credit and criminal background checks and the cost of running those. So it's not like landlords are making money hand over fist on those fees. To Delegate Pippi's point earlier, I know he's not in the room, but it does say on page 5, lines 6 and 7, that making an oral or written inquiry into any person regarding a prospective tenant's proceeding or shielded record is prohibited. That reads to me that you can't call a prospective applicant's prior landlord and ask them about their rental payment history. That would not be allowed. And so we have concerns with that. And I know my time is ending. So for those reasons, we urge an unfavorable report.
Thank you, Madam Chair, members of the committee. Bill Castelli on behalf of the Maryland Realtors. Many of our members are property managers. They do typically represent kind of smaller landlords renting single-family properties. And one of the things I wanted to address, you'll hear the specifics, and we share the concerns on the specifics of the bill, is that one of the fundamental reasons why many tenants are filing for many different applications is because, as the Maryland Department of Housing and Community Development Housing Needs Report shows, there is basically 2 tenants for every 1 affordable housing rental unit. So there is an undersupply of affordable rental housing units. There has been a 15-year history in Maryland of underbuilding, and that is driving a lot of the problems that tenants are experiencing, a lot of the reasons why tenants come before the legislature and seek new laws trying to address some of these issues. So I think that's a big part of what drives this, and I think it is also a big part of what the solution should be. As far as the issues, we agree with the 30-day compressing the time. We spent a lot of time in Maryland trying to extend those time periods so that tenants have time, especially when you're getting notification that your lease might not be renewed. It's now at least 60 days for most people, and if we're going to compress that time to 30 days before a landlord can even run a report and tell them that they can get it, we don't think that's in anybody's interest, not the tenants and certainly not the landlords. So we look forward to talking to Delegate Von Stewart some more about the bill, but those are our concerns.
Good afternoon again. For the record, Matt Pipkin here on behalf of the Maryland Multi-Housing Association. I won't repeat the points, or I'll try not to, from my colleagues that are right of me. Definitely serious concerns with this legislation. I do want to stress, I mean, this bill would de facto prohibit housing providers from considering things like chronic lateness or even active delinquency of rent when evaluating the prospective tenants. And what do I mean by that? As you've heard, one of the express intents of the bill is to not be able to evaluate if someone files for an FTPR, if they were to pay rent action, and it doesn't get a judgment. Now, as many as we've heard, sometimes the hearings on these don't occur until 3-6 weeks out. And, by that time, maybe the tenant has paid back. And however, they may, in fact, have not paid that rent for a full month. They paid it back to the landlord. They don't have to go to court over it, so there's no judgment to be had. Our housing providers wouldn't be able to consider that. And I think that's a big, big thing. I mean, we're trying to make practical assessments as to whether or not the applicants are going to be able to afford our units. Again, I will also push back a bit. I believe if this bill passes, I think I may go back to law school so then I can go and represent the housing providers with the legalistic and liabilities attached to it. I mean, the problem is, I mean, we are in large part dependent on these third-party actors in assessing and calculating the risk assessments. If they're able to pull records and we don't even know about it, I'm not sure why the legal onus on that would be back on that housing provider. And with the teeth, as we've elaborated on, for those reasons, we urge an unfavorable report.
Good afternoon, Madam Chair and committee members. My name is Mike Cerrito. I'm a real estate broker in Upper Marlboro, 39 years experience in a family business that's in its 67th year. We do a lot of property management in addition to sales, mostly single-family detached homes. I have one question to start off with. Why do we think a law in the state of Maryland is going to make people do what they're supposed to do when the Fair Credit Reporting Act is not being followed? Is the Maryland law is going to make them follow the law all of a sudden when they're not following the federal law? I'm glad the sponsor is not going to die on the hill in 30 days at the beginning. That's good. The simple response to that is make sure that the housing provider advertises when the property is going to be available. If it's 30 days, 60 days, 90 days, 120 days, gives maximum flexibility to the tenant who knows whose future of where they want to be may be dependent on something further out than 30 days. So giving written disclosure advance of rental requirements, minimum requirements, very important. Giving contact information to the provider of information, what are they going to do with it? Fair Credit Reporting Act already says use the adverse action letter. It gives all that detail. That tenant can, up to 60 days after they hear that they're denied, they can request a review from the credit bureau. The bureau provides that information, not us. So we don't want to be held up as a landlord waiting for somebody to question information provided by a bureau. The bureaus, most that I know of, are subsidiaries of the three major credit bureaus, not some college kid in a basement. When you provide So when you provide that adverse action letter and they're denied, we do it quickly because we want to move on to the next applicant. We're not waiting around. We don't want to be held up waiting. Sorry, my time's up. I did provide written testimony with a lot more detail. Thank you.
Thank you. Vice Chair Charkoudian.
Matthew, right? Yeah, I just want to follow up. I think, is it your position that you think that an accusation against a tenant that the tenant has cleared up should be able to be held against them? Like the next landlord should be able to consider that and deny them housing based on that? Is that your position?
I would say my position, and again, when it comes to these risk assessments, there's a lot of different things.
Okay, but I'm talking specifically about.
Sure. I would say this, if there is a pattern where you've seen multiple months have gone on, where the individual has you have the notice intent, right? So we have the 10 days that have already happened.
So now I understand all the steps. What I'm trying to understand, because in this state, we've already passed a law that you can't use that against them. And so what this bill does is it says, now we're cleaning up the way that credit reporting agencies or risk reporting agencies are doing their job, right? And you're saying you want the risk reporting agencies to be able to scrape the data that we've already said you're not supposed to be considering? Is that?
I think you might be tying in with the shielded records, which is, again, is separate from the failure to pay rent actions that don't actually end up going anywhere. I mean, that is still readily available on the reports and can be considered.
I have an example I can provide.
No, that's okay. I don't need you to price, but I just want to make sure that I'm understanding what you're saying. You're saying that if a landlord takes a tenant to court and the tenant is not convicted of anything.
Correct.
No one wins or loses. That should be able to be held against them.
What I'm saying is.
You're saying yes, you think that should be held against them.
I'm saying if there is, again, if you see a pattern, if we're seeing, 2, 3, 4 failure to pay rent actions,
So even though a court never took a position on it?
Correct, but it was enough to
So if you have 2, 3, or
file.
4 landlords who use those strategies regularly, and a tenant just happened to be in 3 or 4 of those buildings, right? So you want to be able to use accusations against tenants or filings against tenants as opposed to court outcomes against tenants? Is that?
I want to be able to catch patterns to make sure that we're able to.
Patterns of accusations, filings.
I
Okay,
mean,
I got it. Thank you. I'm clear though. Thank you. I appreciate it.
Okay.
Are there any other questions for this panel? Seeing none, thank you very much. That concludes the bill hearings on House Bill 313. We'll move on to our final bill of the day, House Bill 315, also Delegate Stewart.
All right, yeah. Can I bring a panel up? Yeah, thanks. All right. Thank you again, Madam Chair, Madam Vice Chair, members of the committee. For the record, my name is Vaughn Stewart. This is House Bill 315. So this bill also relates to tenant screening, but it's quite different, so I don't want to get too much conflation between the two, so I'm going to try to make it crystal clear. The previous bill dealt with incorrect, obsolete, junk, old data that's still on tenant screening reports and is rendering people homeless across the spectrum. This bill is narrowly targeted. Now we're talking about a specific population of Maryland tenants. And these is a population of tenants who hold vouchers. Sometimes these are called Section 8 vouchers. These are vouchers. So 70, 80, 90, sometimes 100% of their rent is paid for by the government, by taxpayers. And we actually have a voucher program now in Maryland that Delegate Wilkins set up a few years ago. So there's a federal voucher program and a state voucher program. So this whole bill is just about that population. Previous bill was all the tenants. This bill is just about voucher holders. And so let me start with a different scenario that unfortunately is happening a lot in the real world. A mother leaves an abusive relationship with her children, and her credit is damaged. Not because she's irresponsible, but because of medical debt, sometimes her partner's debt being held over against her. So then after going through extensive screening and verification and vetting by a housing authority, she receives a housing voucher. This is basically her golden ticket. For someone in a dire financial position to receive a housing voucher is like the Willy Wonka golden ticket. Her finances stabilize all of a sudden. Her rent share now is set by law at an affordable level. The rest of her rent absent the amount that she's responsible for, is paid for by taxpayers, by the government. So she finds a safe apartment in a good school district. The unit passes inspections. She's excited for her kids to go to this new school. The landlord will be paid reliably every month, but there's a hitch. She's denied anyway because her credit score is really, really low. Now, this may not shock you, but voucher holders have crappy credit scores. They have bad credit history by definition. The reason they were able to qualify, the reason they were needy enough and low income enough to qualify for the housing voucher is because they've had challenging economic times in the past. And a lot of times that has manifested in a very low credit score. But unfortunately, now 5 years, 6 years after the legislature passed the HOME Act, which, as y'all will probably recall, banned what's called source of income discrimination. The legislature actually considered this bill for 30 years. We never passed it. And then finally in 2020, now Comptroller Brooke Learman introduced the bill, and we banned source of income discrimination. So what we said was that the very, very small minority of landlords who were denying tenants the ability to rent with them because they were voucher holders, they can't do that anymore. That was the right call. We did it. I know not everyone here voted for it. Not everyone in this room was here, but we did it. And it was a big victory because most landlords understand the reality, which is that voucher holders are really good damn tenants. They're already vetted by the federal government or the state government. A lot of times they have background checks and they have guaranteed rent. Again, 70, 80, 90% of the rent every year from the government. What a great tenant. But unfortunately, a very, very small minority of landlords had a bias against voucher holders, and we stamped that out with the HOME Act, or so we thought. Unfortunately, a massive loophole has arisen that, again, a tiny, tiny fraction of landlords are using to dodge what we did in the HOME Act, and it manifests in two ways. The first way is that they are saying, this tiny little fraction of landlords are saying that you have to show enough income that's 3 times, 4 times the total rent, even if you're only responsible for paying $0 of the rent, 5% of the rent, 10% of the rent, 20% of the rent is your responsibility. The government's covering the rest. The landlord is saying you've got to show enough income to cover the entire rent. Now, I think that's a pretty flatly a violation of the HOME Act, but this makes it clear that it is. They're dodging the HOME Act in a second way that I think is very clearly a proxy for source of income discrimination, which is that they're saying that even if your credit history looks good after you got this golden ticket, right? And a lot of times it does. We're going to look back at your credit history and your credit score prior to the golden ticket era. And to me, that's obviously discriminatory, because if I'm a landlord and I've got a tenant coming in, like let's say that mom who went through an abusive relationship and she got her voucher in 2024. And prior to 2024, her finances were a mess. She couldn't pay her bills. Her partner maybe was abusing her and also abusing her credit card, which unfortunately happens a lot. But then she leaves him, she gets the golden ticket, and she's paid on time all of her bills every single month since 2024. Her credit score is still bad, mind you, but now she's got a clean credit history. I think that in 2026, if a landlord denies her, I think that's pretty obviously discriminatory, because I think that denial has to be a proxy for source of income discrimination, because why else wouldn't you want to rent to that woman? Everything else seems great. And so what this bill basically says is, number one, you can't do income tests based on the full rent. You can only do income tests based on the amount that they owe. Number two, you can't use credit scores. Now, the landlords are going to say, we have to use credit scores, we have to be able to vet people, yada, yada, all kind of the same arguments they just made in the last bill. Here's the problem with that. Multiple peer-reviewed studies say that credit scores for tenants are not predictive about whether they're going to pay their rent. They're not predictive. You know what is predictive? Eviction history. Kind of like what those guys said. That's why they should be able to, both with the other bill and the current bill, they should be able to know if tenants have been evicted before, if there are judgments against them. They should get references. Tenant screening reports are not in this bill. They can still get tenant screening reports. They can get eviction history all day long. But credit scores aren't predictive, so they're out. And then the last thing is the bill says, and this is actually a compromise based on a bill that I introduced that was in ENT last year. You can't use credit history from prior to the voucher. Now, you can use credit history after the voucher. So if someone gets the golden ticket and they still can't pay their bills, The landlords should know about that. I agree. They should know. If their credit history is still bad and they're missing these credit card payments and they can't pay this and they can't pay that, and they've had the golden ticket, the voucher, I think that landlords should know that. But if it's credit history from before the voucher, I don't think that's fair to use. And so this bill, I think, is narrow. It's operational. It's based on what's already passed in jurisdictions. And it's about basically finishing the work of the HOME Act. We did a good thing 5-6 years ago. It's mostly working. But unfortunately, a few entrepreneurial landlords, not the majority, not the vast majority, have found a workaround, and we have to pass this bill to close the loophole. Thanks.
Madam Chair, Vice Chair, and members of the committee, thank you for the opportunity. Again, I'm Adria Crutchfield, Executive Director of the Baltimore Regional Housing Partnership, and I am here in strong support for HB 315. Every day, we help economically disadvantaged families access the same things we all want for our children: safe neighborhoods, good schools, and the promise of a better future. The bill is designed to address key barriers that circumvent the intention of the HOME Act by keeping assisted families out of desirable housing while promoting more relevant screening alternatives. For these families, the impact of credit-based screening is not abstract. In a recent survey of participants in our program who moved last year, they reported submitting an average of 13 applications before being accepted, and nearly 50% reported credit as the most common reason they were denied housing. Families use scant resources to pay application fees and prepare to move, only to be rejected because of a credit score that existed long before they have received rental assistance and does not reflect their current financial security. Parents working multiple jobs, caregivers managing medical issues, or someone trying to escape an unsafe environment have their years of hardship continue to follow them in the form of a number that overrides their rental history and guaranteed assistance. These are common themes in the testimonies from participants included in our written submission. Credit-based denials directly undermine the purpose of housing assistance, which is intended to stabilize families so they can focus on work, school, health, and long-term economic resiliency. National guidance from HUD cautions housing providers against over-reliance on credit scores, noting that credit scores were not designed for rental decisions and pose a significant risk of unjustified discriminatory impact. HB 315 recognizes the reality of assisted tenants and ensures that screening reflects what actually predicts successful tenancy, like rental history and landlord references, paired with the vouchers program's built-in income and affordability verification and other safeguards. For these reasons, BRHP respectfully urges a favorable report on HB 315. Thank you again for your commitment.
All right, good afternoon again. Vice Chair Valderrama and members of the committee, Zephyr Shaw, Maryland Legal Aid. We urge a favorable report on this bill because there should not be a loophole that allows source of income discrimination, period. I want to cover one of the rationalizations for that loophole, something that sounds very logical, but when you actually look at the facts, it turns out to be a distraction. And that's the idea that when a voucher holder presents themselves to a property owner at the application stage, that there needs to be additional income testing, an income multiplier, as Elliot Stewart mentioned, or a credit score check. What's actually happening at that stage is that the voucher holder has been extremely vetted. I want to talk to you about what some of the steps are for that voucher holder before they even present themselves with the application. So the Public Housing Authority has already verified all their sources of income through a third-party verification system. It's mandatory. It's called the Enterprise Income Verification System. That looks at not pay stubs like some landlords might look at. It looks at their employment records in full, their benefit statements, and their tax returns. That system has access to their social security number, their benefit information, unemployment information, whether they received compensation. It has federal wage and data information that landlords are not going to have through Department of Health and Human Services. The PHA has to project the income 12 months forward, not just assessing a point in time like the application. The income has to be re-examined annually. And when there's a change in income, there's interim recertifications. There are hardship exemptions where a tenant will have to present why they need to lower or increase the amount of their subsidy because of hardships that come up. There's asset verification, imputed calculations. So this is all information. I'm happy to answer questions about it. This is information that every
tenant has when they apply for their for their housing opportunity. And we urge a favorable report.
Good afternoon, Vice Chair Balderum and Vice Chair Charkoudian and members of the committee. Thank you so much for having me today. My name is Nicole Earl, and I am the President of Dominion Community Development Corporation, an impact investment real estate development firm in Baltimore City. I'm here to express my support for HB 315. I'm not speaking about housing policy in the abstract. I'm speaking as someone who lives and works with families who are trying to survive, stabilize, and thrive. Families who are all doing the right thing, who have secure income and who are simply wanting a chance to live in a safe housing with their children. This bill, because it addresses something that's happening across Maryland, it's not a fair bill. It's exclusive and discriminatory, and it's not what real opportunity looks like. This is about real families, real people. I'm thinking about a woman, my neighbor, who lives with her beautiful children, and she's not asking for charity. She's asking for, not asking for a free ride. She's asking for an opportunity, a fair chance to give her family a fair opportunity at a better life. She has a stable income through housing assistance. She's trying to keep her and raise her kids in a decent environment, but many like her are running into closed doors. And because no other reason besides credit score. Stable income is stable income. HB 315 sends a basic message. If a person has secure income, including income-based housing assistance, they should be treated not less than for housing. Housing subsidies exist because we're a society decided that working families deserve that. So a credit score should not be used as a backdoor way to deny someone who has a reliable ability to pay their rent. At Dominion, we have a mission to rebuild communities, and we need to work to provide safe, stable housing for families who have a right to pay. Let me be clear, this bill, nor do I support removing responsible screening, but this bill does not provide landlords from protecting their properties. As a landlord, I want that right. And so I support this bill. And in closing, I ask that you approve HB 315.
Good afternoon, honorable committee members. My name is Liz Kruger. I'm the Director of Homeless Services for Interfaith Works, a Montgomery County nonprofit where for 53 years we've served individuals experiencing homelessness and poverty. Interfaith Works supports HB 315 not only as a moral imperative, but also as an economic imperative. We believe that homelessness, well, we know that homelessness is exorbitant in cost, and any legal loopholes that cause it or prolong it should also be seen as such. And currently, an individual experiencing homelessness costs local and state governments anywhere from $5,000 to $35,000 annually. And that is not a cost that communities can continue to absorb, especially as the number rises every year of persons experiencing homelessness across the state of Maryland. So in Montgomery County, for example, last year there was a 34% increase in homelessness overall, 80% for families. And this is like an unacceptable cost that has many root causes, many reasons, but one of them is absolutely delayed access to housing. And we know firsthand, because we have seen it, that there are households that wait 4 to 6 months or more with subsidies and vouchers as they apply repeatedly for housing and are denied based on credit. We've long suspected discrimination, and in fact, Health and Human Services in Montgomery County recently did a fair housing test along with the Equal Rights Center and found that a group of landlords and property managers, about half of them were culpable for discrimination. This is confirmation of something we long suspected, but it also is distressing because we believe landlords stand to benefit from working with public housing authorities and with voucher administrators in a time where so many cannot pay the rent. This is guaranteed income. Thank you for considering.
Thank you. Delegate Bandari.
Thank you, Madam Chair. I really like the delegate passion. If I understood this bill clearly, is it your intent that landlord may still screen tenants for neutral factors like prior evictions or criminal history, so long as they do not categorically reject applicants because they use lawful housing subsidies that is already encoded in the state law. Did I understand your bill correctly?
That's exactly right, Delegate Badari. I appreciate that. Yeah, we all this bill says is we want landlords to use predictive tools. Eviction history is predictive. If someone wants to use a criminal background check because someone has some sort of violent criminal history, that's not in this bill either. But if they want to use credit scores, which aren't predictive, if they want to use old credit history that has nothing to do with the circumstances of the tenant today, and if they want to use these income multipliers, I think they're trying to sidestep the HOME Act, and I think they're doing a lot of Marylanders a disservice, and that's why the bill is here.
Thank you.
Seeing no other questions, thank you very much for this panel. Thank you, Delegate.
Thank you, Madam Chair.
Now calling on Jennifer Bevan Dangle and David Wheaton.
Albert Turner signed up?
Oh, yes, but every time I called, they said you weren't here, so, okay, thank you.
I apologize, that was only for the first.
Okay.
Good afternoon, Madam Chair, members of the committee. My name is Jennifer Bevan Dangle. I'm the Deputy Director of Economic Action Maryland Fund. The first panel explained the bill incredibly well. I do not want to belabor the point, especially as we are the last bill on your docket. I think it is so important to reinforce that this does not prohibit screening for other factors. It is simply these specific clients with a specific question around the credit score and their income. And I think it's incredibly important to keep in mind that, as the sponsor has said, someone's income before they receive that voucher is going to look vastly different. Their credit score is vastly different because housing is such a significant percentage of a household's monthly budget. So once they get that voucher, once that helps stabilize their income, the predictive forward look is going to be very different than how their income was previous to that point. So this is a very fair and equitable bill, and we urge a favorable report.
Madam Chair, Vice Chair, Albert Turner, I'm an attorney with the Public Justice Center, asking for a favorable report on House Bill 315. I'll just say that we submitted our written testimony. I do want to kind of highlight the importance of a voucher. As the sponsor has stated, the voucher is a golden ticket. Prince George's County just opened up their enrollment for vouchers. For 5 days, they had 47,000 applicants. Of those 47,000 applicants, only 5,000 of those were going to be chosen. So it is literally a golden ticket for someone to be able to find housing. In addition to it being a golden ticket, it is also a ticking time bomb, because when you get your voucher, you have, generally speaking, 60 days to find that house. If you do not have 60 days, you might be able to get 30 days, which is 90 days. But if you're not able to find it within a certain time frame, you're at risk of losing that voucher and going back on that wait list. So it's imperative that a person is able to take advantage of all the available options in front of them. If I can put this into real terms, I had a client who had gotten a voucher. Her rent share was $0. She was due to pay $0 for her rent. She had a full voucher. She lives in Annapolis. She applied to over 20 places, and she was rejected every single time because of her credit score. Rejected for a credit score for rent that she was never going to pay. She was eventually able to find that within the 60 days, but it was very, very close. She had to find a place that was 20 miles away from where she intended to live. She had to find herself a place that was not within the same range where her kids went to school, so her kids had to go to a different school. And so by this denial, it radically changes the trajectory of a person's livelihood, because they are looking to move on. They have this voucher, they're able to qualify, and they're being denied because of something that has nothing to do with whether or not they're able to pay for their voucher. Ask for a favorable report.
All right. Good afternoon, Madam Chair, Madam Vice Chair, members of the esteemed committee. My name is David Wheaton. I'm an attorney with the NAACP Legal Defense Fund, and I want to talk about the racial justice ramifications for this bill. Founded by Thurgood Marshall in 1940, LDF is the nation's oldest racial justice law organization, and I'm here today to testify in support of Maryland House Bill 315, which would eliminate unnecessary income and credit exclusions for recipients of vouchers and other housing assistance. Despite Maryland's source of income protections, landlords often exclude prospective tenants based on their income or credit history, even if their rent will be paid by a housing assistance program. These policies disproportionately exclude low-income Black Marylanders, who make up more than 70% of those who use housing assistance and housing vouchers in Maryland. House Bill 315 would ensure Black households and other low-income renters are not unfairly barred from housing. LDF urges this committee to give the bill a favorable report. Just some other statistics. Some Black consumers actually have no or lower credit scores due to historical inequities that have reduced wealth and limited economic opportunity. Roughly 1/3 of Black borrowers do not have credit scores because they are disproportionately lack access to bank branches and other credit resources. Also, according to a 2022 study, Black consumers have a median credit score 100 points less than white consumers' median credit score, which can lead to unfair bias in accepting an applicant's lease application. Also, as testified, landlords often rely on inaccurate credit information, leading them to deny low-income families rental applications through no fault of their own. A 2017 study conducted by the National Fair Housing Alliance found that 4 out of 5 credit reports contained errors and 54% contained inaccurate personal information. And so, without delay, just relying on income and credit history ignores financial security of the housing subsidy and disproportionately excludes Black families. We ask for a favorable report on House Bill 315. Thank you.
Thank you. You didn't have to speak so fast, but thank you for the testimony. I know you're trying to beat the clock, but I would let you wrap up. Delegate Howard.
Center, just walk me through that application process. So the woman goes in, she's got a voucher, 100% of the rent is covered. Walk me through that application process.
So the application process for most of those, and I've seen the application denials, right? Generally speaking, you apply and then you'll get maybe an email or you'll just get a PDF printout saying you have not been approved for this unit, and they give a reason. And generally the reason is really short. It just says credit history or criminal history or something nondescript.
Is that universal where it's like an automated application service? So there's no navigator or person that they talk to?
So for those, that was usually something that was used through, and I think the sponsor in the previous bill kind of alluded to this. A lot of this is kind of AI generated, and a lot of this is pulling from and creating these reports. And so essentially the landlord is getting a third party to say whether or not this person is qualified or not, and then they give the reason, and the reason is given to the tenant. And so it depends on what the landlord wants to disclose and what doesn't want to disclose. But I've seen denials based on credit score where it just says credit score. And
I mean, I think we've all seen those at some point in our life. And everybody's been in the military or college or something, and we've all gotten something like
and it's even frustrating it was frustrating for my client because she's like, I'm not paying any rent. I'm going to be paying $0.
Yeah, I'm just trying to get a sense of it. Sounds like it's a procedural matter. I mean, it sounds like there's no redress for the person. I mean, quite frankly, I don't think it's I don't know. I mean, we can argue the merits of the bill or whatever, but I don't know if it's a credit issue or what, but it sounds like the person just needed to talk to another human being and say, I'm being kicked out of this system, so to speak. And I know tens of millions of Americans across the board and all economic stratas and educational stratas and stripes of life suffer the same in the job market, based on AI filters and things like that. So that's why I wanted to get a sense that it almost sounds like it's a application process. Not so much, I don't know. I'd have to look into it a little bit more. I don't want to say one way or the other. I'm not trying to disparage anything, but it sounds almost like the person just needs somebody to talk to sort of go through some of their circumstances.
And I think to the extent that I agree with you on that. I think when we first came across this client, she had already been denied so many times. Right. But she had, in some of those instances, called up the property management company and said, hey, I was denied based on my credit score. Did you know I have a voucher? And they said, we did. However, these are our metrics. This is what we were told, and you unfortunately did not qualify based on that.
Yeah,
so
probably wouldn't want to live
she had taken steps
anyway.
beyond just getting the rejection and moving on.
Yeah.
She had taken the next steps to try to figure that out.
All right, thank you very much, though.
Thank you, Delegate.
Seeing no further questions, thank you very much for this panel. We have several virtual favorable witnesses, Mandy Crumpton, Kiara Gilmore, and Tanika Richardson. Who? Okay. Kiara, you're muted.
Hello, can you hear me?
Yes, we can hear you. Thank you.
Okay. So, hello, I can start?
Yes, please.
Yes, ma'am. My name is Kiara Gilmore, and I respectfully submit this testimony in support of HB 315. Before I got my housing choice voucher, my daughter and I had nowhere to call home. We were sleeping in our car. Couch hopping with my friends, scraping together whatever money I could afford from Lyft and food deliveries to obtain a hotel room for the night. Some nights we made it, some nights we didn't. But constantly we were in survival mode. When I reached out to the Office of Homelessness Services in Baltimore, they were told they told me that I had already filled out every application that was available, and I felt completely hopeless. Through what I can only call divine intervention, someone from Baltimore Regional Housing Partnership reached out about an old application that I had filed. She told me that I had an old address on file and asked me to update it. Neither of us knew that that email would change my life. Had she not reached out, I would have missed the chance to successfully obtain any housing assistance, and we may still be living in my car today. Getting housing through PRHP wasn't just about a roof over our heads. It gave us stability. It gave us breathing room to rebuild. For the first time, I was able to provide my daughter the kind of life that I wanted her to have: a safe home, a community, a real opportunity in life. Since joining the program in 2021, I've had two jobs. My longest job has been 3 years. And while none of them offered benefits like health insurance or retirement, my income has been far more stable because I'm no longer consumed by the question of where we'll sleep every night. I even found a neighbor who helps me get my daughter to school so that I can commute to work in the morning. However, there have been setbacks. I lost my job when I was hospitalized due to my complications with diabetes. I lost another when I no longer had a car and had to move closer to the city. But through it all, my voucher helped me stay housed and safe. And that housing has allowed me to keep moving forward physically, mentally, and emotionally. Life is not predictable. People are dealing with real life challenges, health issues, mental health crisis, lack of transportation, childcare struggles. Even with the voucher, the road hasn't been easy or paved. I had horrible credit because not because I was careless, but because no one ever taught me the importance of responsible credit use. And because of that, loss of work and homelessness took a toll that followed me on paper.
Ms.
Doors
Gilmore?
closed.
Ms. Gilmore, I appreciate you sharing your personal story. If you would like, you can sum up in a few seconds.
Okay.
Thank you kindly.
So because of that, doors closed. Because of my credit, doors closed before I can even explain my story. So finding housing became discouraging and exhausting. But I hope lawmakers understand that stability creates opportunity, and that people like me just need a space to breathe and rebuild. And housing is not a reward; it's a basic human right.
Indeed. Thank you so much. Thank you kindly.
No problem.
Okay, I guess our other virtual witnesses dropped off. With that said, we'll now move on to the unfavorable. Aaron Greenfield, Michael Cerrito, Bill Castelli, and Brian Anlou.
Good afternoon again, Madam Chair, Madam Vice Chair, members of the committee. Brian Anlu with the Apartment and Office Building Association. We oppose, I'll start off by saying that we certainly agree with the principle that you shouldn't use income multipliers when the person has a voucher, but we do think that income qualifying the person for their portion of the rent is very important. You heard that vouchers seldom cover the entire rent in Montgomery and Prince George's County because the rent is so high. You know, it might cover 50, 60, 70% of the rent, and so we should still be able to use income as a qualification for the tenant's portion of the rent. As to the credit screening portion, it seems to be lifted from DC's law, or at least it mirrors DC's law, but there's some very important differences between the way Maryland's Housing Choice Voucher Program works and the way DC's program works. In DC, because they have rent stabilization for a lot of other reasons, the way the program is administered is not on a citywide basis, it's on a property by property basis. And so the landlord doesn't even know how much a voucher or subsidy a tenant or applicant is getting until they call the Department of Housing and verify how much the Department of Housing is willing to pay for that particular property based on its conditions and how it is. In Maryland, you get a housing choice voucher. It's a fixed amount for a specific jurisdiction, say Montgomery County, and you go and you find a unit that you can afford at that amount based on how much your portion is. And the landlord has no way of knowing how much or when the housing choice voucher was issued or credit history issues that may have happened before it was issued. You just know that the person has a voucher. There's no way to verify when it began and any relevant adverse credit history. And so the proponents seem to be saying two things. Credit history is not a good indicator of whether a person will pay their rent on time, but you can consider after they get the voucher any adverse actions that happen post that period. And again, we don't have a way of knowing when exactly they got that voucher. For that reason, we urge an unfavorable report.
Madam Chair, Madam Vice Chair, Aaron Greenfield on behalf of Maryland Multi-Housing Association requesting an unfavorable report on House Bill 315. Similar to what Mr. Anlu just said, housing providers must continue to screen for income, even when an applicant receives a housing subsidy, because subsidies, as you just said, typically cover only a portion of the rent. It's very infrequent that you have a 100% subsidy. If that were the case, we'd be having likely a different conversation. However, subsidies are not guaranteed forever. Adjustments are done on an annual basis, and a resident's financial situation can change due to job loss or failure to meet program requirements, which can result in a loss of assistance by way of example. As part of a credit history review, housing providers also evaluate an applicant's rental history. Rental history extends beyond payment performance and includes whether the applicant previously caused disruptions or issues in their community and or issues with other residents. This gives us some sense of how to assess whether a prospective resident is likely to comply with community rules and regulations. We have a responsibility to residents, lenders, and property owners to ensure that housing remains financially sustainable. This is just not a business concern. It helps prevent eviction and the significant social and economic costs that come with housing instability. This bill would undermine the process by preventing housing providers from assessing income, credit score, or credit history. Without these tools, providers would be forced to take on excessive risk, which could ultimately lead to more evictions and reduced housing availability. For these reasons, we respectfully request an unfavorable report.
Thank you, Madam Chair. Members of the committee, Bill Castelli on behalf of the Maryland Realtors. And I won't repeat what they said, but just to give some context, you know, a lot of the property managers are representing landlords who own single-family properties. Some get into the business because they want to use it as an investment. I can tell you there are plenty of owners of rental family properties, single-family rental properties, who are what I would call unintentional landlords. They get it because of the economic circumstance they're going through. It might be change of duty orders where they're get change of duty orders to go to another military base in another state, but they have their house that's invested here. They don't want to lose money if they just purchase the house. There have been plenty of examples of that. And so they're now in a situation. When they hire a property manager, they will often have many different tenants apply for that property. And what they want is the best tenant who is going to be able to be successful in that property, pay for it, And that is the responsibility of the property manager, to make sure that they've found the best tenant for that person. And so it's not a question of sometimes whether they would be a good tenant. It's oftentimes a question of whether they would be the best tenant for that property. So we think this is an objective measure that everybody can use, and we are unfavorable on this bill for that reason.
Good afternoon, Madam Chair and committee members. Mike Cerrito, Realtor. So I'll agree with everything that Bill just said, but I want to point out in detail that the legislature and the bill sponsors don't take into account the huge difference between multifamily and single family. As Bill alluded to, you have a single family owner that may only have one property. We like to not discriminate against anybody, so we like to use the most objective and uniform screening processes that we could possibly do. Credit scoring is extremely objective. What I anticipate happening is if this bill passes, you will now cause a housing problem for non-voucher holders because there won't be any housing left if we can't screen tenants. You have a single-family homeowner, maybe military, maybe PCS'd in another country. They depend on the rent, but they also depend on everything else being covered, including utilities being paid, like WSSC, water, which if it's not paid, comes back against the owner. So I think this will unintentionally cause a housing shortage for non-voucher holders. There's two people in every transaction. There's the landlord, the owner, and the tenant. You can't just put everything in favor of the tenant. So we don't want repeated vacancies. An apartment complex can handle repeated vacancies because they may have 300 or 500 units. Single family, we don't want repeated vacancies. We want a tenant that's going to come, stay, and pay, and leave when they're done, so that we can find somebody else to do it with the least amount of time in the mix. So the burden is too high for landlords to try to now screen tenants in a different manner based on their criteria that you're talking about here. Thank you.
Thank you. Before I take questions, I just want to make sure I heard what you said correctly, Brian. You said that because their vouchers don't always cover it 100% in its entirety. I just want to be clear that you meant that's not an automatic rejection, is it? Because clearly they don't provide 100%. I just want to make sure I understood what you said.
No, it's not. I apologize if I misspoke. What I was saying is that you're still able to income qualify the person based on their portion of the rent. So if their portion is 30%, then you should be able to income qualify that person and make sure that they're able to cover that 30% of the rent.
Okay,
That's what I was saying.
I misunderstood. And then, Aaron, you mentioned that, I think it was you, Aaron, said that these vouchers don't last forever, but I want to be clear on what you meant by that comment. So they don't last forever, but you're not saying that's already, again, same question that I posed to Brian.
Yeah, that's not an automatic, it is certainly not an automatic denial, but it would be a reason to reevaluate the applicant, right? If there is a loss.
But if I may, but it's guaranteed money, right? If I understood how the voucher works, right?
Sure, it is guaranteed money. However, if there's a change in circumstance, let's say they get a job that pays them more, that would trigger a reevaluation of the subsidy. And so we should then be able to reevaluate whether that applicant can pay for things like renter's insurance, utilities, and the like.
So you're saying that if that circumstance happened, then they shouldn't be able to use the voucher any longer because of that circumstance?
No, I'm saying there could be a change in the split of the subsidy. It could be more, it could be less, depending on the change in circumstance, and we would need to have that ability to assess whether they can pay not just their rent, their portion of the rent, but utilities, renter's insurance, and those kinds of items.
Thank you. I'm sorry, Vice Chair Charkoudian.
Madam Chair, I just want to make sure that we're understanding the bill the same way. So Brian and Aaron, you both said you should be able to do the verification on the X percent, 30%, 10%, whatever it is, right? As though that's part of your opposition, but the bill allows for that. Do you read the bill as though it allows for that, or you think the bill doesn't allow for that?
No, I do read the bill that it allows for that, and to be
Okay.
clear, we're objecting to most, I think specifically is the credit portion of the bill, and not being
Okay.
able to screen for credit specifically.
Okay, I just, because it was a little bit confusing, so I just want to make sure everyone's on the same page. If they owe 30%, you can income verify 30%, right?
Yep.
Okay. And then on the credit stuff, I think the bill's language is reasonably considered. It's not sort of like a strict liability. Like, you're saying you don't know when the voucher came into effect, and so you can't figure out like what time frame you can look at a credit score? Is that what you're saying?
Yeah, partly. So, again, in DC, it's very clear. You have to call the housing authority. They tell you, here's the voucher amount based on your property, and you can verify, a landlord can verify when the tenant began receiving that subsidy.
So you would be like, okay, so X date, before that I can't count it, after it I can.
Exactly.
So if we could solve that problem in Maryland, and it may be solvable, I don't know a lot about how those dates show up in Maryland, but assume we could solve that, would that take care of your concern then?
I think in part, I think the overall point that we're trying to make, and, you sort of hear the proponents arguing both sides of this, is that on the one hand, they don't think that credit is a reliable indicator of whether someone's going to pay their rent, but they acknowledge that if the person has a voucher and they don't pay their bills on time, that could be counted against them.
So I can't speak for them. What I heard them saying is generally credit shouldn't be counted, but if you want to count credit, then count credit after they've fixed the situation they're in, right? I mean, what I heard was that there's academic papers that show that it's not a good indicator, right? And that you can count things like eviction. I mean, you also mentioned, I think, Aaron, you want to be able to consider rental history. As I understand this bill, you still can consider rental history. So I don't want to, it's late, and I don't necessarily want to go like what I think they said, but what I think the bill does, let me go with that, because I want to make sure we're together on understanding what the bill does. What I think the bill does is it says you can income verify them on the portion that they're going to owe. It says you can consider credit after whatever the date is, and maybe we need to work on figuring out how to establish that date. I think, based on what they said, and I'm going to ask them for the academic papers because I'm interested in seeing them, it's irrelevant because credit doesn't matter. But we'll find out. Let's study the papers. And the third thing it says is you can still consider rental history. You just can't consider the thing that potentially is not a good indicator of where they're at right now. Do we agree on that part of it? What the bill says, whether you like it or not? I just want to make sure we're clear on what the bill says.
I agree on those points. If I may, Madam Vice Chair, I would just point out the previous bill was saying you cannot consider rental history. So,
well, the previous bill said you can't consider rental history that's not real history, right? You can't consider a court action that a court didn't take is what the other bill said. But let's have that conversation about that bill. So let's do one bill at a time. On this bill, you can consider rental history. Is that right? Like, would you agree that's what it says?
Yes.
I know you may not like it.
It doesn't say you cannot, so
Okay.
perhaps.
Okay, fair enough. So you're worried about it in together with other bills.
Yes.
Okay, got it. Thank you. Thank you, Madam Chair.
Seeing no other questions, thank you very much. With that said, that is the end of House Bill 315, and that concludes our bill hearings for today. I will just put a reminder, if you saw in your email, there is a multi-committee reception this evening, if you're so inclined, at RRW, which began half an hour ago.